wanted to tell everyone who's here for the licensing of acupuncture that that section has been removed from the amendment. So all that to do with acupuncture has been removed from the amendment. Does anybody have any questions about acupuncture? No. Okay, great. The next one has to do with, let me just go back. Let me see if I can find the MLADAC board. I know that there's someone here from them. And what we had, because that also is not going to be addressed by any of the upcoming bills, that's going to stay. And then I was given some changes. Where are they? Here they are, from the MLADAC board on some housekeeping. And there was also a concern about, just a moment, it had to do with RSA 330C colon 16 Roman numeral dash 2 dash A, either it had to do with credentialing, and that's been removed. That's going to be removed from the bill. So is there any questions or any concerns from the MLADAC people? Yes, please, one of the OPLs, if we could have OPLC board representatives come and speak, that would be great. And if anybody has any questions from the committee, just raise your hand.
Elizabeth Eaton, Board Counsel to the Board of Licensed Alcohol and Other Drug Use Counselors.
Yep.
And the board just wanted to note a couple of things. Thank you for updating on what's already been changed.
Which version are you working with so that I'm on the same page as you?
I have the
Is it-
original, and then I have the clean copy, the new copy.
Okay, let's work with the original.
Okay. On page 8 of the original, it's at the top of the page, line 1. It adds a section Roman numeral 2A, and the language is unclear. Neither the board nor I understood what that was adding. And
That's being removed.
okay.
Is that the one? It's on the top of page 6 for me.
Oh, okay. I apologize.
Did you see it on top
Yes.
of page 6?
Yes.
Okay, that's being taken out.
Thank you. And then just 2 of the repeals were also, we had questions about that.
Is this on page 7?
Yes.
So the first one is at RSA 330-C colon 3, relative to the liability of the board. That's been moved to RSA 310.
Okay.
Is that what you had?
No, so the 2 concerns were related to RSA 330C5 Roman numeral 7, which is repealing the approval or denial and withdrawal of approval for providers of continuing education. And the board would like that to stay in, but maybe read criteria for approval so that they're setting the criteria, and then the office is actually doing the issuing of approval or denial.
This is RSA 330-C57.
Roman numeral 7, yes. And I believe on that page it's on line 13.
Yep, I see it, and I
Okay.
have it. This was part, the response from OPLC was that this has to do with licensing and fees.
This is for the relative to the powers and duties of the board is 330C5.
Okay.
And
So
and
it's
just
page, okay, I'm going to just write myself a note.
okay.
Page 7, and it has to do just with the code, with Roman numeral 7, right?
Yes, under 330C5 Roman numeral 7.
Yep, that's it. You're talking about just this one. Good. Okay. All right, I'll look into that. Do
Thank
you
you.
have, if the board or you could come up with some
Yes, I can send some.
alternative language, that would be great.
Absolutely. And then one more, and this is just kind of the board is just wanting to make you aware that this would be removed. It's on the same page, line 18. So RSA 330C 16.5.
Mm-hmm.
That is relative to the issuance of an MLADAC license. In that
Mm-hmm.
provision, it is if an applicant does not meet the requirements for an MLADAC, but they do meet the requirements for a LADAC, that allows the issuance of a LADAC license under that same application. And the board would like to keep that if it does not conflict with the 310 statute.
Okay, can you check with
Mhm.
Doug and Mr. Osterhaus?
Yes.
That would be great.
Yes, absolutely. And I believe that's everything that I have on behalf of the board.
Okay, thank you. So after that, we have barbering and cosmetology. Are there any comments? Okay.
Yes. I also represent barbering and cosmetology, and I have a number of questions there. So this is, okay, I'm going to go section 23, I believe on your page 8.
Yes, maintenance of records. Oh no, barbering and cosmet. Yeah.
Yes, maintenance of records. Right now, that line 5 says the board shall maintain a record, but I believe this should be the office maintaining those records. So change board to office.
Okay.
There's an editorial issue on line 9. It should just say and registration certificates. With a space between and
Yep,
and
I
registration.
see
Okay.
it.
Okay. On line 19 and 20 of that same page, report to the Office of Professional Licensure and Certification all violations of this chapter. That, I believe, should be repealed as it's an OPLC function. We did try to get the office's opinion on these changes that the board council noted, and time just did not allow the communication back from the office. So we're making these proposals, and if general counsel disagrees, then that's fine.
Okay. Yeah. Right. Yes, it's because in 655 last year, we changed the responsibility of licensing to a office function, and also record retention was also changed. Yes, the amendment, these are just oversights. So it should be on line 5 on page 8, it should be the office shall maintain a record, not the board. Yes, that's right, because either these are the duties of the board. I know, that's why we have to go through this. No, because these are the responsibility of the board underneath this. And these are sort of, it's not a continuum of different, it's just areas. Thank you for the question, though.
Board or office could be interchangeable in the document. Is that
No, because the office is where the office is the administration of OPLC, and the board are those like the board of cosmetology, the board of, and they are responsible for example, setting up the standards, and they're two different functions. I know. I wish they were. Thank you. Okay, Ms. Eaton. continue.
Okay, thank you. On the next page, um, we have an outstanding question with the office that we haven't received feedback on, but I did want to make you aware as the sponsor that the criteria for licensing shops was not included in this section.
Can you tell me what line or?
It's just not in here.
Okay.
Yeah.
Are we talking about Roman numeral 3?
So it would be included in between, and since this was repealed and
Yeah.
reenacted, I don't know where it would go. But
Okay.
in the original language, there's a section 10, which is rulemaking for conditions and standards for operation under a shop license, including health and safety standards.
Didn't we get rid of shop licenses?
We got rid of booth rental
Oh,
licenses.
booth rentals. Okay.
But shop licenses are pretty important, and especially the health and safety standards.
Yeah.
So again, I haven't received feedback from the office on that, but
Okay. And that was section 10.
correct.
So where did that go? Okay.
So I don't know. It could go.
I'll find. We'll find. it.
Yes, I'm sure you will. And there's a number of places where I think Director Courtney has already noted using criteria established by the board should be added. And so I have noted those in my copy, but I think Director Courtney has also already noted those areas. So I'm not going
Okay.
to go through every single one.
Right.
Unless-
No, but
okay.
as long as so it's the criteria set by the board.
Yes, added in certain sections here.
Okay, this is underneath barbering. Okay. Okay.
And that's everything that I have for barbering. There are a few things that may be beyond the scope of this amendment that the board would like to change, but I don't want to bring it up if it's
No.
beyond the scope. So
Okay.
Thank you.
Right. Okay. Thank you. So now we're at see, barbering and cosmetology goes on for some time. Body art. Is there anything to do
We,
with-
Rakia Medley, Board Council, we didn't have any changes for the section involving body art from the Board Council perspective.
Okay. And then there's a section here. All right. Okay, we have the Board of Dental Examiners. Were there any changes involved with that?
Just, there was chiropractic.
Yes, chiropractic before, yep.
Yep. Are you okay if I go through that?
Yes, if you just tell me what page you're on. Yes, hi.
Hi. Page 15. Douglas Osterhout, OPLC. Page 15, line. Oh, where is it? Here's a different.
Yeah, mine is.
Let me get mine.
Okay.
Okay, you want to tell me what page to start with?
For chiropractic?
Yeah.
Or do you want to wait on body art?
No, for chiropractic.
Okay. Chiropractic, we're on page.
Yeah, it's just that.
should be certification.
Yeah.
Oh, okay. Sure. Just let me note this so I don't forget this.
Mr. Osterhout, if you want to jump in and join everybody at the microphone, you can, but we're taking it like,
Yeah, on page 15, line 36, we wrote Office of Professional Licensure and Responsibility and not certification. So it's just a.
I see line 36. Can you repeat that?
It says Office of Professional Licensure and Responsibility,
Yes,
section 48.
yes.
It should be in certification.
Oh. All right, thank you. Is there anything else on chiropractic or is that it?
That was body art.
Okay.
Chiropractic.
No, I mean, page 15 is chiropractic renewal.
Oh, I apologize. But just to be clear, Douglas Osterhout was discussing a section within, but okay. Sorry, I apologize. Um,
So
Eh.
are we at,
I'm at section 43 on the original copy, line 44.
this has to do with chiropractic?
Correct.
Line 44? How about 34?
Chiropractic
Ru-
fees, qualifications.
What page are you on?
My copy is, I think on yours it's page 14.
Yep.
Okay. At the bottom of the page,
It says, should say criteria or set by the board. Is that what you're saying?
it's 44, section 44, chiropractic fees, qualifications, amend RSA 316A, colon 11, Roman numeral 1. This, I just want to make sure that,
This is not on page 14 on my copy.
okay, I don't. the
Can
orig-
we deal with what you, the paper, so that if you're just dealing with something that's, I can't follow you.
Right, and so I'm,
We got moved across the hall, so we're not. we can go past that.
Thank you. Okay, thank you. All right, please, go ahead. Sorry.
thank you, thank you.
Are you talking about chiropractic fees and qualifications, section 44?
Yes.
Okay, okay, go ahead. We're on what's, each applicant shall pay to the Office of Professional Licensure and Certification a fee established by the board office? Is that what
Correct.
you're reading?
Yes, that is what I'm reading.
Okay,
So this section in the statute was referencing fees. There were other various items within there that needed to be addressed. And I believe this needed to be with the office just to review and revise that section. There were just some items that weren't picked up within within 316A5, which needs to be addressed in that area as well.
Mr. Osterhout, do you have a comment on that?
My question was just what the reference is, so I can take a look at it and then
Yep.
make the modification.
Three 316A colon 5. And then I believe 316A colon 8. Yep. So those just need to be addressed as being a reference for the office.
I'm not sure Mike and I say we're on the same page.
Thank you. She should
I
have
can
had one.
move to
Okay.
Which side is better for you? He likes to.
All right, well, you know what? We'll have to deal with that.
Yeah.
Separately.
I'll just stay.
You might as well.
Are we still on chiropractic?
No,
Give me one moment. No, that was the only, those are the only
Okay,
two.
so we can go to Board of Dental Examiners.
Correct.
Okay, any comments on Board of Dental Examiners?
Let me just find it on your copy real quick.
Well, maybe if you just tell me what the section is called.
Section 60.
Section 60, okay. 60? Wow.
And so it's on page 20,
Uh-huh.
line 4.
Yep.
Failure to do so may result in the board issuing a non-disciplinary letter of concern to the licensee.
Mm-hmm.
This is inappropriate under the new statute, OPLC.
So it would be the office issuing?
So I believe this should be struck. This
Okay.
sentence should be struck.
Oh, I see. So failure, okay.
Just as a comment, if anyone is here for the LNA qualifications, they're meeting in room 305.
Good. Okay, and then now, are there any other comments on dentistry and dental hygiene, which is the next one, 61?
Just one more comment. It's in the repeal section on page 21.
Okay,
Again, it's just one that is missing from the repeal section. There's a section in the dental statute on the professional health program. This is an outstanding question we have with the office, whether they need a section in their statute on the professional health program, or if the OPLC statute on the professional health program satisfies.
can you comment on that, Mr. Osterhout? Do you want some time?
Thank you, Lindsay Courtney, Executive Director, OPLC. I think you could handle it in one of two ways. I don't view it as a conflict. Essentially, there are 3 boards that are statutorily authorized to have a PHP. One is actually mandatory, I think, for nursing. But then the office has the ability to provide a PHP pursuant to rules and or contract. And so we do provide a PHP to other professions. So I think you could either repeal it, because I think we already have the statutory authority, or I think you could just leave it as is.
Okay, so what's your flavor, Miss Eaton?
I believe the board would like to leave it as is.
Okay, so it's not missing then?
No.
Okay, we don't need to address that. Okay, great. The next one has to do with dietitians. Anybody here for dietitians? No? Okay.
Sorry,
go-
Rikia Medley, Board
Yeah.
Counsel for Dietitians.
Yes.
Just to confirm,
This is on rulemaking, section 70?
uh,
Or is there something before that? I don't think so.
no, there wasn't anything that needed to be addressed for the dietitians on the original copy.
Or 71. Okay, then we're 72, section 72, right? Or section 74. So that would bring us to the Board of Electrolysis. Section 76? No?
We didn't have any changes for
Okay,
Board Counsel.
all right. Then we are at electrolysis. Electrologist. Electrology. Okay, we're still at electrolysis. Oh, okay, funeral directors and embalmers. Is there anyone here? Do you have any comments on that?
I'll be here on behalf of funeral directors. Their Board Counsel is unable to make this subcommittee meeting.
Yep. I have section 83, funeral directors and embalmers. Section 86, funeral directors qualification. I skipped 85, sorry. And embalmers qualifications.
Largely, these were the changes were fine. There are, as other professions, there are some items for the future that would need to be adjusted. But at this time, I don't think it works with this amendment.
Okay. So nothing on funeral directors or embalmers. And if human remains, or there's nothing about that. If there's no changes about that, we can go to
There is one under, excuse me, section 99, cremation of human remains.
Yes.
Repeals.
yes.
It would need to change the language from RSA 325A 11 to leave that, but to change the language from board to office.
Okay, so we're not going to repeal that, and we're going to change board to office.
Correct. That is the recommendation from the board.
Okay. Thank you. Then we have repeal for massage therapists and massage establishment. Since there's nothing that board is not changing right now, we're gonna those are repealed. I would imagine there's nothing about any changes there.
That's correct. No changes.
Okay, and then medical imaging and radiation therapy.
No changes.
Okay. The Board of Registration of Medical Technicians, we're going to leave that in because right now, even though there's a proposal to take it out, we don't have, that hasn't passed yet, so we're going to leave that alone. The Board of, okay, Medical Technicians. Let me see. Okay, physician assistants.
We have no changes for physician assistants.
Okay, good. We have midwifery.
The changes noted to the midwifery statute here are only related to whether they stay a statutory board or go to advisory. If they go to advisory, the changes are fine. If they stay statutory, they should change some of these back from office to
Right.
board.
So which ones should change because that's a proposal and we haven't passed that yet. So I don't want to make any conflict with what's going on right now. So it needs to change back to what it was like.
Yes.
So should we leave all the language that's been struck out, for example?
No, but I can get you
Okay.
a full written copy of what's here as should be changed back.
Okay.
Yeah, I can send that to you.
Okay. Telemedicine has to do with, okay, naturopathic healthcare practice. Anything there?
Herkia Medley, representing naturopathic board. No changes noted from the language that was provided.
Okay, great. Nurse Practice Act 129.
Yes, we have a few things noted here under section 128, the rulemaking authority.
Okay, hang on a second.
Under Roman numeral 4,
Let me find section 128. Where the heck is that? Oh, yes, okay, room number, yep. The
Um,
standards to be met by and the process approval for,
Right. So the process for approval of
yes.
is now an OPLC function and should be stricken, that phrase.
So the standards to be met by education programs, so we just,
Correct.
okay, take that out. Okay,
Further, in Roman numeral 7,
yes,
says the administration of examinations, and administration is now an OPLC function. It should read the requirements for or criteria for. Either one of those would work.
the criteria for the administration of, is that where it's gonna go?
Criteria for I don't know if administration is.
We'll deal with that, we can talk about that separately.
Okay.
All right,
In Roman numeral 10, and I believe the office also flagged this, persons regulated by the board, it has, in the original amendment, it has that stricken in office. It should be persons regulated by the board.
and retired persons regulated by the board as well,
Correct.
all right? All right, and then we're continuing, anything else on the Nurse Practice Act?
Yes.
Okay,
Roman numeral 13.
yes,
This process for registering practitioners, it's the DEA registration is not a nursing function. This Roman numeral 13 should be stricken entirely.
it's not a function of, repeat that?
It's not under the authority of the nursing board to require registration with the DEA.
Okay. Is that going to be, though, so one of the things that we're doing is we're trying to, oh, that has to do with LNAs, never mind, all right, fine.
Okay. And then in Roman numeral 14, it says the implementation of strategies and procedures. And so procedures should be stricken from that. So it reads the implementation of strategies necessary.
All right. Yes. Representative Goley has a question.
I just want to go back to 13, the process for registering. I mean, I understand that DEA does that process, but shouldn't we still be tracking those and have a process of knowing who has that under federal regulation and prescribing controlled drugs? Why wouldn't we want to have a registry as well as a DEA?
Lindsay Courtney, OPLC. So we do track the information. The statutory authority was limited to defining the process for registering with the DEA, which is the DEA controls that process. So I don't know that we could adopt rules that would conflict with the DEA process for registering. We do capture that information as to whether or not somebody has a DEA number, but I don't think we can dictate the process.
Just to clarify, I read it as a process for registering practitioners who have been granted special. So
Right.
this is a process for us, not for a process to tell them what to do, is the way I read it.
It's a process for our licensees to register with the DEA, but that's a DEA process because our licensees aren't registered. They have a DEA registration. Our licensees are licensed. So I think that terminology means to me that we would be dictating our licensees' process for registering with the DEA.
I have a recommendation. What if we change it to a registration of practitioners who have been granted a special
You could just say requirements for registration. I think that would be fine. I think when we think of process, though, we
I
don't
know,
want to
that's
have
why I'm
any.
taking the word
Yeah.
process out.
Yeah, I think
So
that's
it's
fine.
just,
Sure.
it's a registration of the, however you do it, it doesn't matter.
Yeah.
But we want to have that registration of the practitioners who have been granted, right? So I'm just going to say a registration of practitioners who have been granted a special registration. That way we have, and we can noodle out how we're going to do that later, but I'm going to change it for this way right now, and then we can discuss how it's going to be done, okay? Because I don't want to get stuck on, not that this thing isn't important, but
Okay.
we still have 80 pages to go.
Sure.
Okay, so Nurse Practice Act, Section 129, do we have any concerns or questions there?
No concerns until we get to section 133.
Okay, let's buzz over there then. If I can, does anybody know what page? Okay, 133, that's only on page 41. Okay,
So this is relative to temporary licenses,
Yep.
and I believe the office's version removed this section because temporary licenses are now under the OPLC. Just wanted to note that this should be eliminated.
oh, it's not part of the Practice Act anymore?
Right. The
Okay.
board isn't issuing temporary licenses. The office is.
So do we have this captured in 310 somewhere, Mr. Osterhout? The temporary license, is it all temporary licenses, period?
It's under 310.6, Roman numeral 5.
Okay, all right.
Yeah.
Okay,
And
Thank
as
you.
you recall, all licenses, license approval and denials, that has been transferred to the
Right.
office.
thanks. I just want to make sure that it's somewhere. Okay, and then section 134, do we have any, or 135 or 136?
We have nothing until 138.
Okay. 138 is on page 40. 42. Okay. Yep.
And then it's in Roman numeral 4.
Oh, Roman number 4. Okay, that's on page 43. The office shall.
So, and this is another question, and maybe Mr. Osterhout could speak to it. The board's duties and powers and duties under 326B4, it gives the board the power to do this periodic review of education programs and standards. And so when this section transfers that power to the office, it seems to conflict. So I just wanted to make note of that and get the yours and the office's opinion on whether and how that conflicts.
Do you have a comment on that, Mr. Osterhout?
I don't think there's a conflict. And earlier in this bill, we talked about transferring, and I think it's more consistent with the board establishing the criteria and the office doing the approval of the licenses. And if that's changing to education programs too, which the recommendation from the Board of Nursing was to do, and I agree with that, then I think the same would hold true here. They could set the criteria, but we could do that review and then also rely on the subject matter experts if needed.
Okay, is the conflict resolved?
Yes.
Okay, great.
And
Where are
then
we?
one more.
Yeah.
In the repeal section,
Mhm.
I believe it's already been noted to you, but the repeal relative to scope of practice, 326B14.
We're gonna, that's not gonna be in there, and
Okay.
also, the relative to examinations. That's not gonna be repealed.
Okay, and then 321A is relative to the licensed nursing assistant.
Correct,
Okay.
that's staying, correct.
Thank you. That's it for nursing.
Okay, and now, nursing home administrators, since they are not, they are still a board, right? They're not advisory. Is there anything that needs to be changed here? And if so, can you just give me the, like you will with the midwifery?
Yes, I'll just give you a whole write-up.
Okay, great. That way we don't have to go through all that. Nursing home, admin. Okay, and then occupational therapy is on page 47.
There are no changes.
No
needed.
changes, okay. Oh God, I can't even say that word. Ophthalmic dispensing.
The board council does not have any changes
Okay.
for
That,
ophthalmic dispensing.
right. Optometry licensing. Anything there?
One moment. I believe in section 154. It's under Roman numeral
7.
7.
We're gonna leave it. We're not taking that out.
Okay, that was my question.
Yeah, that's gonna stay as is. Anything else to do with optometry? If not, we are at pharmacy.
I don't remember this comment. Oh yeah, that's right. Just one more under optometry, section 160. There's a question about
Section 150.
160 optometry repeals.
Okay, yes, we're
but-
gonna leave in relative to penalty. We're not gonna repeal that. Is that what you meant? Is that the concern you had? Or was it something else?
No, it was the joint credentialing committee. I wasn't sure why this was eliminated, but I believe it's not been utilized.
So that's why we're repealing it?
I believe so, yes.
Okay, so that's gonna stay, okay. All right. Pharmacy,
One moment.
sorry.
There's it's just a lengthy section.
No, I
so I
know.
just want to get
I'm
make sure I
on
have everything
161, pharmacy definitions.
correct. We have nothing until 172, Roman numeral 3.
Okay, 172 is on page 54. Roman numeral 3, the commissioner shall adopt rules. Yes,
And for, so the commissioner shall adopt rules under RSA 541A to implement this paragraph. Such rules shall include procedures for addressing complaints and for reporting to the Board of Pharmacy on the status of complaints referred. I believe that would go to the office. Complaints are reported to the office, not to the board at this time. That was in last year's
okay, so it
legislation.
would be such rules shall include procedures for addressing complaints and for reporting to the office as opposed to the board, right?
I believe so, yes.
Okay. All right.
And similar comment for under 173, section 173.
Yes, I get it. Okay.
Okay. And that is all we have for pharmacy.
Okay, then we can move to physical therapy.
Just one question for physical therapy under section 179.
Yep.
In other practice acts in this amendment, the injunctive relief statutes have been repealed. And so the question is, why is this staying? Is it regarding title protection? So that was the question.
Mr. Osterhout, can you answer that? Or someone? Well, it says RSA 328 F12 is repealed and reenact, so you want to know why it's being reenacted? Okay,
It really is for about title protection.
Okay.
There are certain statutes, certain professions have protections on their title in
Mhm.
particular. So I think that's the genesis. I agree though, they don't need injunctive relief because it is already provided for in 310.
Mm-hmm. Okay. The reflexologist section 181 was removed from the amendment, so we are going to speech language pathology. Is there any comments or concerns about speech language pathology section?
Yes, I do.
Okay.
One moment, please. And just so the record's clear, there were no changes for reflexologists, structural integrators, and agent bodywork therapists
Okay.
from the board council perspective.
Okay.
With speech language pathology, 184, there was just an editorial note to its speech language pathology and hearing care providers. I just want to make sure that is reflected. That's the way the statute reads.
So are you saying that 184 should be called speech language pathology and
And hearing care providers.
hearing care providers? Okay. All right.
And then section 188.
Yep.
My understanding from the board, they reviewed this, that the reference to the sale and fitting of hearing aids should be removed from that. So that should be struck.
Okay. Oh, yes, I see that. It should, okay. All right. Is that it?
I believe so.
Okay.
Yes.
So now we're at the New Hampshire Board, New Hampshire Accountancy Act.
Yes. One moment, please. There was under 197 a comment that we do need to discuss with the office regarding substantial equivalency.
Okay, that's on page
I-
61, line 18. So that,
So
Okay.
309B6,
Yep.
substantial equivalency. We just need to consult with the office with respect to that section.
okay, so you're gonna, do you have a comment, Mr. Osterhout?
I think that's the process we're using under 31017 anyway, so the language might be a little redundant, but I don't see any conflict.
Why don't we just take it out? So we're gonna remove, we're not gonna have, we're just gonna eliminate it, and we're not going to, it's just gonna say it's gonna be repealed, and we're not gonna reenact it, okay? We don't need it in two places, because that's a problem if we have to change something later. Is that the only comment, Ms. Medley?
Give me one moment, please.
Sure. Yes, did somebody have a question? Oh, you said bless you. How kind.
That is all for the accountancy board.
Okay, perfect. So now we can move to. My goodness, this is long. I don't know if I've. Okay. Architects, page 70. The bottom of page 70. Are there any comments on architects?
Excuse me, not for this bill. In the future, I think there's going to be some changes that will need to be made.
Okay. And why are we saying that in the future?
It doesn't fit under the scope of
Okay.
this bill.
Okay. Okay, architect, auctioneers.
Auctioneers, under the scope of this bill, we do not have any changes. Again, that's another one in the
Okay.
future.
Okay. Court reporters. So court reporters still exist. So we're going to pretend that we're going to, so who's going to rewrite this section on court reporters? Because I think this was written as if it was going to be an advisory board. Correct? Or am I? No?
The bill proposed was to eliminate court reporter licensure,
Right.
and that failed. So I can take a look at the language, but this should be written as if the court
Okay,
reporters
so Mr.
exist.
Osterhout, you're going to look at section 218, court reporters. Okay, so I just want you to know, we have to exec this by next Wednesday. So we'll talk about when, because this still has to go to OLS, and they're finishing up this draft today. I think you all should send them some flowers after that. I'll help with the flowers. Electricians, finally, electricians. Do we have any?
So Elizabeth Eaton, Board Counsel for Electricians. And I just have three areas that are being repealed that the board wants to note that shouldn't be repealed.
Okay, let me just make sure. Oh, that's on page 76? Oh,
Yes.
no, that's court reporters. Wait a minute. Where is
It's
the-
there. Section 223, it is on page 76.
Okay, yep.
So the first line, 24, a journeyman electrician shall be employed by a master electrician. The board considers this to be a public safety matter. There are additional steps that a journeyman needs to take to become a master, including business education and other such matters. And the concern is that a journeyman will be a 1099 contractor with a master, and they think that that relationship is inappropriate for the supervision level required.
So they're not, the next sentence, I think, clarifies that by saying that each journeyman electrician shall work under the direction and supervision of a master electrician. You think that's too loose?
The board wanted to
Well, the board, I'm sorry, not you personally. When I say
Correct.
you, I'm talking about the electrician board, please.
The board really wanted to tighten up that employer-employee relationship.
Okay.
Representative Gerda, can I just make a comment on that?
Yeah.
I think it's problematic, and the reason is that they have electrical corporations and they have felt very strongly about wanting to keep that license. And the reason for that is to allow people who are not master electricians to essentially own a corporation, employ a bunch of people, which may include a master and a journeyman. The master supervises the journeyman, but the master is not the employer. So there's a conflict in the law there. And I think that that's why it needs to be repealed in order to allow them to have that function with respect to the electrical corporations.
I think that this is something that we need to noodle out. I know what you're saying. I understand the board's concern too. So I don't know if we should say a journeyman shall report to the master electrician in some other, I know what you're, well, this is, we'll have to talk about this.
Okay. I'm just raising the conflict in the
Yep.
law.
I understand.
Sorry.
But I also understand what the electricians care about, which is, okay. Is that the only comment from the electricians?
No.
Okay.
On the next page, I believe it's next.
Is it
yes.
319C6? We're going to keep that.
No, it's in the section above, 319.5A.
319.5.
There's a sentence eliminated. The board shall maintain and make available a list of such persons approved for level 1 or level 2 third-party electrical inspections. The board believes that this list being made available is important. So you could change it from board to office. The office shall maintain and make available a list of such persons.
Okay.
And then just one more when you're ready.
Okay, hang on a second. All right, go ahead.
So you said 319C6C?
is staying. We're going to keep failure to complete the continuing education shall render the electrician's license invalid until licensee demonstrates to the board that he or she has completed the requirement. So we're going to leave that.
Okay. In,
Okay, and then it says proof of completion shall be, sorry. Proof of completion shall be furnished by the board by the continuing education provider.
I do believe, and the board agrees that to remove the conflict, it should be proof of completion shall be furnished to the office.
To the office. Okay, all right. Is that it? Oh, Mr. Rancourt has his hand raised.
It's okay to change the board to office, but it's still saying continuing provider, right? Or are we changing that? Because the way it's written, I believe now we're supposed to submit it.
You need to speak into the microphone because this is a bit public meeting.
Steve Rancourt, licensed electrician, I apologize. So I just want to make sure that it doesn't still say by the provider, because I don't think they have a process to take that by the provider. I believe some of the law changes or rule changes were making the electrician submit it now. So we just want to make sure that's clear. Is it still going to be by the provider, or is it going to be by the licensee that is submitted? That's all. 'Cause
Okay.
we had a third-party
I have
software in place.
provider circled. So I'll licensee. I'll write myself a note and we'll check it out. Thank you for that. Okay, you can go back. So are we done with electricians now? Okay. So now we're gonna go to family mediators. That is staying, right? We didn't make that advisory. So is there someone that is going to go through that and make sure that you will do that? Okay. 2:30. Okay. Foresters, which is 2:34. Yes.
What? Just give me one moment. I
Sure.
apologize.
So there's supposed to be another subcommittee meeting at 10:30 in this room, but it's going to happen after this because we're going to keep going on this. We're almost done.
Getting there. Section 234, foresters. I believe. I'm sorry, I'm reading the wrong one. I think there was some legislation pending on this one. This is our other board council.
Right, we're not going to do anything with them. We're
Okay.
going to leave them alone.
Okay.
So does that mean that this has to change?
No, I believe this should be fine.
Okay. You've got until Friday to tell me it isn't. Okay. So we're going to skip foresters and then we're going to guardian ad litem. Are there any changes to that? If not,
One moment, please.
yep. We're not going to do anything with guardian ad litem at the moment.
Okay. So this.
Page 82. Guardian ad litem, page 82, line 9, it says, second half of that sentence, the issuance of a license by the board shall be evidence that the person named.
Okay, hang on. Okay, I'm sorry. What section are you on?
Page 82, section 238, line 9.
That's foresters. Is that what you mean? Did you
I
say?
mean foresters.
Okay,
Sorry.
foresters. Okay.
Um,
Line
says the
9.
issuance of a license by the board.
Oh, okay.
We just need
It should be office. Okay. All right. Thank you. Guardian ad litem, anything?
Yes, one moment.
Mr. Simon, if you need to leave, I'm talking, if you need to leave, we can address your concerns after this. You're okay, okay. Thank you. Does this legislation conflict now because this was tentatively to be an advisory board, but it's not going to be now, so do you want to take a look at it separately, or?
There were some items as written that were noted.
Okay,
So section 243,
yes,
under Roman numeral 2, the
Yes.
new E, it was G.
the new E, yes, which is,
Gather such information
Yep.
concerning applicants for certification as will assist courts to make an informed decision on whether or not to appoint an individual as guardian ad litem in a particular case.
mm-hmm,
I don't know that that is necessarily a board function so much as an office function, as it pertains to receiving information about applications and applicants.
okay. I'll check with the office on that.
Sure. And a similar comment to the new F under that.
Okay, so both E and F.
Correct.
Okay. Any other questions on guardian ad litem?
Not for so for section 245 under the repeals, Roman numeral 2, there was a question regarding whether or not if this would be replaced with anything. It's 490C5, Roman numeral 2E, relative to the requirements for resignation.
I think we need to look at this section in
Okay.
more detail,
Okay.
so we'll do that.
Sure.
Can I?
Yes,
Do you think we should postpone the meeting on 1622 because looks like it's going to take a while?
well, I don't know, how long do you think 1622 will take? I'm sorry. Oh, 1622, is that the
No.
one that we're doing together? Ah, that's your bill. Are we gonna, can we do it after this? I think 16?
I've just spoken to the folks in the hall and just told them.
Okay, we're almost done with this. I think we're gonna keep going and we're gonna,
Okay, I just wanted to
yep,
check that.
thank you. Okay,
Excuse me, before
Yeah.
we move on,
Yeah.
top of page 85,
Yep.
certification issued by the board. Change
should be the office.
Yes, ma'am.
Okay. Geologists,
Just a grammatical change. Section 247, Roman numeral 1, H. Just need to add an and after the semicolon. And I believe it was left in I.
okay. Okay. Is that it for geologists?
Moment.
Okay, because then we're gonna do home inspectors.
Yep, it would be, section 253.
Yep,
Line 14, I believe, by presenting evidence satisfactory to the board.
it should be to the office.
No, I think it's, presenting, evidence related to criteria established by the board.
Okay,
Making a determination in compliance with criteria established by the board.
okay. Okay. Okay, home inspectors.
Home inspectors. I believe, just want to get the section number for you. Section number 256,
Mm-hmm.
under Roman numeral 4, the board shall have the discretion to reject. I believe that should be, that power is vested with the office. So it should change to the office shall have the discretion to reject an applicant.
Okay.
As section 257, I believe, again, there's board approved course. I believe it's courses approved by the office.
Are you
with cri-
talking about line 15?
I believe it starts on 14 and moves to 15. It says continuing education completion in each 2-year renewal period of a minimum of 20 hours of continuing education shall be required for license renewal, provided that 1 hour of the 20 required hours shall be from a board-approved course on appropriate building regulations, including any recent revisions to regulations. And I believe the office would be approving
Yes.
those courses
So it would be
with,
an office approved course?
with criteria.
Right, I have the
established.
office based with the office using board criteria shall approve education courses.
Yes,
Okay,
yes.
all right. Yeah,
Why is the office approving them and not the board? I think the board should have to say we're getting a little too far out of what the intent of the office was when it was created. Boards are supposed to still remain on their own in the functions of what the criteria are for licensing. While the office itself can handle the functions, I still think it's the board who should be approving what is required for the licensing. They have the expertise, they have the knowledge, they're the ones in the field. And I think we're taking that away from them with some of this language we're changing in here, and I have an issue with that. And I know I'm not part of this subcommittee, Madam Chair, but
no, you can,
I
you are
just want to
absolutely
state my concerns over as we're
Right.
going through this, and that's why I'm here.
right. Well, the issue with then we have to have a whole philosophical discussion on that because this is consistent with everything else that we've done.
And
I guess it's something that we need to talk about.
it is, because I think Representative Schmidt was here from the beginning when OPLC was given what they were, and this wasn't the intent as far as we're going here, from what I recall when we first did this.
Okay. Yes.
Thank you, Madam Chair, and thank you, Representative Goldie, for your remarks. I absolutely second that, and the intent was always that the OPLC was going to be the administrative underpinning of the operation, but the substance of the board's expertise, which is the professional, the scope of practice, all aspects in relating to the profession itself, that was going to remain the board. And it was never our intention, and we've discussed this for years, that we were afraid that the OPLC was being given, the executive director was being given authority to exercise oversight and control of the substance of the profession, was never intended to do that, and and we didn't. And the senior members of the committee who had seen this whole evolution, we never wanted that, and we've been discussing that amongst ourselves for years, that we did not want to have that lost sight of. So I absolutely second what Representative Goldie is saying, and I believe that you were acknowledging that that is a discussion that we on the committee need to have. And that was one of the reasons that we voted interim study on 1676, if you recall, because we wanted to use that as a vehicle to accomplish this purpose of getting OPLC focused on the administrative end of things. And so I wholly support what Representative Goldie has just said.
Okay. Well, that's it. I don't want to seem like I'm callous about this, but at the same time, we're operating under a deadline, and we're going to get this bloody thing done. So we're on menu, and we're going to talk about it separately because that's a whole different philosophy than what we talked about in this committee. And I understand the discussion. And although it's nice that the senior members were talking about this together, now that it's here, we need to discuss it publicly. And we aren't going to do that today. Manufactured housing, I think we're taking this out because we're taking that whole section out. Land surveyors. Any comments on land surveyors?
I think there's a question under section 273, Roman numeral 3,
Yeah.
that's been struck if the land surveyor in training is being removed.
Is that your comment too, Mr. Sun? No. Okay. Do you have a comment? It was all removed. Yeah. Okay, so they're concerned about land surveyors in training
Correct.
being struck?
That's correct. It's a comment
Okay.
I received back.
All right. I'll recognize that concern.
And then if that is the case that it is removed, then the section 274 Roman numeral 2 be likely.
We have to speak into the microphone. You're not being heard.
I apologize. Section 274 Roman numeral 2B, if the land surveyor in training is being eliminated, then that reference in that section would just need to be removed.
Right. Or we're going to keep it in if we keep the land surveyor in.
Correct.
Okay.
Yes.
All right. Any other comments on that?
Yes, section 278. The language in the opinion of the board, this appears to contemplate that the board would be reviewing the license. However, the licensing goes through the office.
You mean the whole section?
In the opinion of the board. Yes, if you could just strike in the opinion of the board.
Okay. Thank you. All right. Anything else?
Not for land surveyors.
Landscape architects?
Landscape architects. Section 287, it's line 36, I believe. 310A 154 expiration, all licenses issued by the board. I believe it should be a reference to issued by the office.
Yes.
And that should be all for landscape architects.
Okay. Mechanical licenses?
Just one note, it is in section 290
Section 290.
and Roman numeral 3.
Okay, just a second. I found 291. Yes, Roman numeral 3, yes.
So this has the board with an affirmative vote of at least 4 of the appointed board members. And then skipping the line that was crossed out, it says, and with the approval of the executive director of the Office of Professional Licensure and Certification shall adopt rules. The board is questioning whether with the approval of the executive
Yep.
director is required or necessary.
Correct. Okay.
Thank you.
Yep.
That's it.
All right. And then natural sciences?
Natural scientists, just a concern about section 292,
Yep.
Roman numeral 3, the last line, study or education credits acceptable to the board before being allowed to proceed with the examination. It might be better
Office.
to put should be criteria established by the board rather than
okay.
acceptable to the board. And that
Okay.
would be all for that section.
Okay. Real estate appraisers?
No changes from board council perspective.
Real Estate Practice Act?
Real Estate Practice Act, section 302, Roman numeral 2,
Yep.
C3. I believe it should be proves to the office based on criteria from the commission.
Is that, I'm sorry, can you read the whole sentence? What is
Sure.
it?
What it states now is proves to the commission that
Yes.
the applicant,
Yes.
and if we're following in line with what's being done here, it would be proves to the office based on criteria from the commission or criteria established by the commission.
Okay. All right. Any other questions? Any other concerns on the Real Estate Practice Act?
Yes, one moment. Same section 305 Roman numeral 2. Section 305 Roman numeral 2.
Yes.
It should say and satisfy all requirements established by the commission pursuant to RSA 541A.
Okay. All right.
I think I have that. Yeah, I have that. And again, section, there's a few references. Back to 302, Roman numeral.
Section 302.
Yep, Roman numeral 2.
Let me just try to find section 302. Okay,
I
section.
believe it's page 105.
Yep. Roman numeral 2.
Roman numeral 2, G.
Yep.
Submits evidence of at least 6 separate real estate transactions in which the applicant was actively involved and was compensated or proves to the office based on criteria established by the commission that the applicant has equivalent experience. That may
Okay.
be worded better.
Okay.
But that is the,
All right.
um,
Thank you.
and then we did that one.
Anything else?
One moment, yes. I'm not sure if this was fixed in an updated copy, but section 305, Roman numeral 3. We just did that one, right?
Roman numeral 3. Yes, it says the office instead of the commission. The office may establish a fee.
Yes.
Okay,
Yes,
yeah.
that would be the office.
Yep.
Okay. And that's all I have for the real estate commission.
Okay. We are taking out the septic system evaluators. That's being removed from this bill completely.
Okay.
And then I think
I think
that's it.
thank you. Those are all the comments from
Thank you.
board
Thank
council.
you. Thank you. I want to thank everyone for being here and working so hard on this. And we'll keep you updated on any public hearings or subcommittee work on this. So I'd like to close the, is there anyone else that wants to speak about this? Because if not, I'm going to close the subcommittee on this, and we're going to open the subcommittee on House Bill 1622. And I think Representative Schuett is going to take over for a little while. How's that?
Representative McGuire, I'm just going to go see if Representative McGuire wants to discuss her amendment. Representative McGuire to discuss her proposed amendment number 0306H.
This is at the request of, and in the words of, the Administrative Rules Office, and I think you should ask them to talk about it. It's not really my initiative.
So I'll recognize Mr. Morrell to speak.
Good morning. Michael Morrell, Director of Administrative Rules in OLS. With me is Committee Attorney Kim Reeve. She, I think you all should have received an email a day or two ago regarding this bill. I think it was sent out to everybody on ED&A, and which Kim had drafted. I think I'm going to start out going for that, but Kim is more knowledgeable on it, so I'll let her take over. After, I'm just going to start. I'm sorry. Our memo had divided the bill up into three parts. Those that we think are most important, that would improve OLS rules function. Those that we believe 4, 5, and 11 are housekeeping amendments. Improving OLS rules function was sections 3, 9, 10, and 12. Sections 1, 2, 4, and 6 through 8, we're not taking a position on whether the committee retains those sections or not. Go ahead.
Okay, so I guess I'll start with looking at our memo here that we sent a couple of days ago. So section 3, the amendments there, we're proposing those because they would improve the certification process in 541A15-1. I hope that the bullet points there, or the numbering there, those areas kind of explain what we're doing. Currently, the agency files an adopted rule, then we edit and create revision and source notes, and then that draft certified rule is sent over to the agency, and the agency has 121 days to respond. And then after that 121 days, OLS then works with the agency and gets that certified rule up on the website. The problem is that although agencies have a statutory deadline of 120 days to respond and to certify their rules, that isn't being met. And because sometimes they're taking more than 6 months to certify the rules, then that means that what's currently posted on our website is not an accurate it's not an accurate rule in some cases. So even though the rule has been, approved and has been adopted and is effective, what's on our website could be old. It could be, a year old or more. So if you look in the second part there, the future certification, that kind of describes our amendments. So first, the agency would file an adopted rule with us. Then we would post that as filed rule on our website under the appropriate agency. Then we would take time to edit, create the revision notes, and update the source notes. And then that draft certified rule would be sent to the agency, and we would give them 60 days to let us know whether or not that looks right, if there are any changes. But the important piece is, if you look at number 6, is that after 60 days, with or without a response from the agency, the rule would be certified. And that way we could go ahead and get it up on our website. And so that describes essentially what we're doing. And I know there was some concern that it looked like there were just semantic changes to the statute, but they're not. So they would help us get those rules posted earlier.
Representative McGuire, did you have a question?
I have a question, yes. Do I understand it correctly that right now you have no time limit at all?
No, that's not correct. There is a time limit. Like I said, the statute says there's 121 days for the agency to certify those
No,
rules.
no, no.
No.
This
We?
is for you
Yes.
to, if I
Yeah.
read it correctly, you edit the rule and so forth.
Yeah.
And in this case, the revision gives you a 180-day deadline.
Yeah, so
And that's new?
currently my understanding is that we have a backlog of around 4 months. And so we wanted to give ourselves a bit more time just in case we got slammed with a lot of certified rules. There is some wiggle room there. I mean, we would be agreeable to changing, that timeline. Right now, we do try to get those revision and source notes and the editing work done within that 120 days and back out to the agency. But Mike has been here a lot longer than me and can speak to that process, how it's been working in the past.
Okay.
As Kim had referenced, I think the important part of this section is that, as she said, currently you could have a rule that's in effect, but it's not published on our website for 6 months, maybe even a year. Under the changes, we would, as soon as possible, after the agency adopts and files a rule with our office, we would put that on the website, and it would be just as adopted. We won't have gone through the process with the agency of putting in source notes and making sure all the I's are dotted and T's are crossed. But this has been a problem both with the public and with agencies. We've had several times just in the last year where agencies have put in a rule, gone through a new rulemaking to amend existing rules without realizing they had already done so the previous year. They were looking back at the prior rule, which might have been 5 or 8 years old. And the same thing happens with the public. They will call us and say, this rule says this, but the agency's doing that. Well, it turns out, yes, the agency adopted a new rule eight months ago. And so they were doing what the rule says, but the public looking on our website did not see it.
Okay. So under this process, you'll post it almost immediately with a with some kind of qualification that minor edits are expected.
We would indicate that it's, the adopted and effective rule as filed, so by the agency. So there would be that little disclaimer there. But like I said, once we've done our work with, creating the source notes and revision notes, and sometimes that can take a while too if there have been many changes. If there's been like movement between, taking one chapter and moving it to another, those revision and source notes can be kind of lengthy, so it could take some time. But anyway, yeah, the rule would be posted almost immediately.
Which is a good thing, because I know I've looked for a rule that I know was approved by Delcar, and it's not there. Okay, thank you, Madam Chair.
Okay, so then the next part, sections 9 and 10 would extend the final proposal and conditional approval request deadlines that are currently in the statute. And I'll just read from the bullet points here. It would change the filing deadline for final proposals from 21 days before the monthly meeting to 30 days. It would change a conditional approval request from 7 days before the meeting to 10 days before the meeting. It would create a filing deadline for amended conditional approval request that address substantive comments of 5 days before the meeting. It would prohibit the late filing of amended conditional approval requests past that deadline by stating that no waivers will be granted. And it would eliminate the filing of revised conditional approval requests unless they are filed during the meeting. The reason why we're proposing these is that we are being responsive to committee members' concerns. They often state that with the number of proposals on the agenda, that they do not always have enough time to review those. So our hope is that by shifting this deadline up a bit, we can actually review and get those items posted on our website earlier so that the committee members will have more time to see them. like I said, right now the agenda can have around 30 proposals. And we do work with the agencies, and a lot of those will go on consent, but some of the other ones won't. So, we could have anywhere from 10 to 15 to 20 that could be on the regular agenda. It's kind of, it's proposal specific, right? So we don't really know. But like I said, our hope is that we would get those posted sooner. And we were also hoping that we would eliminate some of this extraneous filings. And what I mean is that sometimes the agencies don't always have great version control. And so sometimes, say, the committee conditionally, say they file a conditional approval request. And then we take a look at it and we make comments. We send that back to them, and then they realize that they need to file a revised amended conditional approval request, and they do that. But instead of using their conditional approval request, they use an older document. Well, then it comes in and we've now have a ton of more comments on it. That can happen. The other thing that could happen is that sometimes they are filing amended conditional approval request only to address editorial comments and not substantive comments. And as you can imagine, with that many proposals coming in, with us reviewing them, that kind of takes a lot of time on us to review those, when we could be looking at substantive issues on other proposals. So like I said, we're doing this in order to have more time for the committee members to be able to review these proposals. The late filed items, they could be filed during the meeting. GELCAR rules do allow for that. They would need to meet the requirements of the GELCAR rule, which is that they mostly resolve all the issues within the proposal. And so we are hoping that with this, it will kind of, we'll get a better product. We'll have less filings that aren't substantive, that are only editorial. And like I said, the main thing was trying to get these proposals in front of the committee members at an earlier period of time. If you think about it now with the deadlines, if we take a couple of weeks to review a final proposal and send that back, or if it takes a week or however long, and then the agency files, and sometimes they are filing conditional approval request at the very last minute, 3 or 4 days before the meeting. That doesn't give the members enough time to review that proposal. So that's the reason why for this amendment.
Thank you. Representative Schmidt, did you have a question?
Thank you, Madam Chair. You've been speaking to the concern that I wanted to address more fully here. I understand completely the idea of the moving forward or back, whichever way you want to consider that, of these deadlines and so forth. But since the administrative rules unit's eyes are in some cases the last set of eyes that see things, because if they're going to go on the consent calendar, I mean, any one of the GELCARs, as those of us who are on the GELCAR know, we can pull it off. But if you put it on the consent calendar because, in your professional opinion, the rule meets all the criteria for approval, then we're not going to pull it off just so we can redo your work. But in those cases, your eyes are really the definitive, and your expertise, not just your eyes, obviously, the definitive decision-making capacity to get the rules right. And I really have a problem with the idea that things can get rushed and they don't get sufficiently vetted. Some things are easy to see. You can see that this is simple, no problem, and you can effectively rubber stamp it because it is right. In other situations, it may be, and it frequently is, more subtle, and it really needs to be thought about, and that needs time. So are you going to have a way of pulling back from the commitment to get it done quickly if you see that It's not going to get vetted properly if it's done quickly.
Well, I think we definitely do. I mean, if you think about it, we get an IP in, and sometimes we get draft versions in. I mean, I was thinking about this recently. Sometimes I could review the same rule 8 to 10 times in any one rulemaking if the agency decides that they're going to send us a draft IP or a draft final proposal. So I think we do take some time. I think the issue is making sure that these get posted early enough. You know, as we go through them, the final proposals, they are uploaded to our website in a meeting packet form for committee review, you know, for committees members to review. And so our hope is that, you know, by reviewing these, shifting that deadline up, then those items will be posted a little earlier, you know, in the process, and thereby giving the committee members more time to review. I do think committee members are reviewing proposals, and they do review the ones that are on consent, because we do sometimes have committee members pull them off of consent. We do discuss items with the chair and vice chair when we're not sure whether or not an item can go on consent. So we do that as well. I hope that answers the question.
Okay, well, thank you for that. I mean, obviously, the sooner that we can get our hands on things to start looking at them, the better it is. The question is whether it's being done sufficiently intensively on subtle things where you have to think about it, whether this is really going to work, because the rules have to work. Otherwise, it's like just saying, well, just jump up there and dunk that ball and say, I'm in a wheelchair, I can't dunk anymore.
Well, I would say that, you know, all proposals get more than one review. So, you know, I'll get the final proposal in, we'll review that. I'll send that over to Mike. He will review it, and then I'll review it again. So I don't envisioning that process changing at all. So we'll still be doing that work. So it will have more than one review.
Very good, thank you. I appreciate it, Madam Chair.
Representative Grota.
Thank you. I take it because your amendment deals with additions to the bill as opposed to comments about the bill itself, that you have no comment on that?
Okay,
I'm looking at sections in the original bill.
yeah.
We have section 2, which talks about OPLC.
Oh, if you look down, Representative Grota, so I was just going to cover the items that were of importance to OPOLS
Oh, okay.
operations first.
All right.
So the next section, which is on page 2 of our memorandum here, is on it would amend RSA 541A19C. That's section 12 of the bill. And this would allow the JLCAR to conditionally approve expedited revisions of forms. And so this is another substantive amendment, and we were recommending this one based on feedback that we have received and just what we have experienced in this process. So the expedited revisions of forms, the EXRFs, right now, there's not, the statute doesn't permit an agency to file a conditional approval request for that. And we have encountered situations in which the agency did need to make changes. And so this would allow for that to happen. Otherwise, they would have to get a preliminary objection or they would have to withdraw entirely. So that was the reason for this one. And it would also allow the JLCAR committee to object to the rule if that the forms are incorporated in. So that was the reason for that amendment. The next ones, section 4, 5, and 11, those are housekeeping amendments. The first one in section 4, let's see, it's the deadline to respond. What we're doing here is making it so that a board doesn't have to file a conditional approval and adoption on the same day. So that's the purpose for this amendment. And then 5 and 11 remove out-of-date references and an incorrect citation. Yeah, go ahead.
And just to clarify, your references to sections 10, 11, and 12 refer to the proposed amendment. Thank you.
Yes, sections 9 through 12 are part of the amendment. Regarding section 4, amending 541A 1910, part of this is because right now, if an agency does an expedited revision to form, I'm sorry, we're talking interim rules. Interim rule process, as most of you know, is a quickened process by which an agency can adopt a rule right away. There are only specific reasons, such as the rule's already expired or is about to expire, or the court has made a decision that affects the rule, etc. Right now, everyone, whether you're a board or commission or whether you're an agency, has the same deadline to file a response to the for the interim rule where there's a conditional approval. And that is very short, 14 days? I think it's 14 days. Well, a lot of boards and commissions only meet once a month. Some of them only meet quarterly. So in order to meet this deadline, they often have to get a waiver from the Director of Legislative Services in order to extend that deadline. This would eliminate that problem.
Thank you.
So the remainder, like Director Morrell said, we did make these recommendations. We're not taking a position on the retention of those sections. We made those recommendations mostly because in response to JELCAR committee concerns. Section 1 would require a rulemaking requirement on the OPLC's retention policy. I won't go through all of this. We do note that, the committee could opt to create a carve out, for rulemaking for the OPLC for this retention schedule. If you look there in the subsequent paragraphs, the Department of State Division of Archives and Records Management has the responsibility of maintaining state records, and they do have rulemaking authority to establish guidelines, but the rules expired in 1990, and so there are no established guidelines. And our position has been that the retention policy clearly falls underneath the definition of a rule, meaning that it needs to go through the 541A process. So if the committee disagrees with that or feels that it should not go through the rulemaking process, you could always do you could do a carve out from 541A for it. But this provides the rationale for why we made the recommendation based on committee concerns.
Okay, now I forgot what I said. As Kim said, we believe that setting up a retention policy in a rule is necessary because it is a rule. It affects people outside the agency. The public may want to know, well, how long are they going to keep this record? Most boards and agencies do have retention schedules. It'll say something like, shall retain all records for a period of 3 years, and otherwise, unless otherwise dictated by the Director of Archives. We think that's very important for people to know. Some of the bigger agencies have more than one retention rule because it depends on, sometimes the statutes require a certain period, sometimes it's a different type of program, and the retention period may need to be much longer.
Can I just ask, what is the feeling of the subcommittee on that issue?
Since it shows up every time there's a question about it, and we keep getting nagged about it, I'd like to either put in a clear requirement or just say it doesn't need to be a rule. We need to decide one way or the other. And if the Director of Archives has let his rules lapse for 35 years, I'd say we may not need to go through rulemaking, personally. But I'm willing to accept either decision by the subcommittee.
We are not sure how much of a burden this would place on OPLC because they cover over 50 boards. Some are advisory boards, some are governing boards. I don't know if they would anticipate having to have different retention periods for different boards. It could be burdensome on that, but I think they would be better able to speak to that than we can.
Thank you, Will. We have Mr. Osterhout here. We'll see what he thinks.
I guess I'm just chatting with I shouldn't be chatting. I do think that the idea of record retention did come up in previous hearings on with OPLC. So if you can recall, Mr. Osterhout, what that discussion was, we could use a refresher when it's your turn.
Okay, so the next section, section 2.
I can tell you that when this came before Jelcar, they did not object on that basis.
Yeah, that's correct. The committee did not object on that basis. So, and I believe they did get a copy of the Excel spreadsheet that outlined the retention policy, right? So on the next,
Would you like to hear from Attorney Osterhout now? Okay.
Yes, I think so. And stick around.
Morning, Douglas Osterhout. Is it morning? Good morning, Douglas Osterhout, OPLC. I mean, I think our stance has been pretty clear that I don't think we need a special carve out for adopting the Secretary of State's rules. I do remember at Jelcar when we had the conversation, the executive director testified there was no objection, and I believe it was Senator Lang made a comment to the effect of we're holding the wrong agency responsible for this. I tend to agree with that statement. I think if the committee decides rules need to be done, I don't think this language is the way it should be done. We do have the policy in place. To address Director Morrell's question, I don't think we've got our spreadsheet, but I that sort of covers everything. But it's not really a different policy or practice of keeping records sent over to archives. Another concern is addressing archives, and I don't know the interplay between if we have the rules adopted and there's conflicts with Secretary of State rules or archiving, or I'm not really sure what the expectation is there as far as are we expected to set up sort of our own archival system separate and distinct from Secretary of State and every other agency? I don't know if that's the intention or what that means. So that is our stance that
Representative Schmidt?
Thank you, Madam Chair. So as as some of us are aware, we have a new archivist, okay? And she was before this committee relatively recently. And she's in the process of reviewing a lot of stuff that may have been, to some degree, gathering dust for a while. But because she's looking at things anew, I think we should reach out to her and try and coordinate things as well as possible, because it's clear that we don't want to have stuff sitting around in the archives that has no long-term value. By the same token, we also don't want to have completely lost touch with it, where you're going like, it's kind of like the checks from 30 years ago. They must be around here someplace, but I don't know where that place is, and it may take me a couple of years to find them, or I could stumble across them tomorrow looking for something else. But we need to have a more flexible system, but also one that is in touch with reality. So I think the fact that we have a new archivist looking at things and evaluating things and making changes as well is beneficial if we work together with her. Thank you.
Representative McGuire.
In response to that and the information, I suggest that we delete section 1 and let the state archivist figure out what should be done. And the statute already requires the office to maintain official records in accordance with their retention policy. That should be good enough unless the archivist comes up with something different. I think that they're totally correct that if the archivist has the responsibility for rules for that, we don't want to have two sets of rules that might conflict.
Can I just ask, does that agreeable to?
Mike Morrell again. Yes, that would be fine. And I would be willing to try to facilitate a meeting with Secretary of State and or the new director, along with Douglas or other representative from OPLC to discuss rulemaking with them.
Thank you. That would be great. I'm guessing we are not going to exec this until the 13th. Is that
That
the
is
plan?
correct.
So,
I'll
yeah, I'm not sure if we'll have another subcommittee meeting, but if we can hear from you if we need to make further changes. Thank you.
Okay. Perhaps we should vote on that.
On section 2, which has to do with OPLC license renewals, I think what they're trying to do is they're trying to clarify what licenses. I don't know if we need that because it's in statute that licenses shall be valid for 2 years.
The reason why we made the recommendation is because many of the board statutes have not yet been amended to remove this conflict. So the OPLC statute 310(8), I think section 2 says that they will expire 2 years from the date of issuance.
Correct.
But there are other board statutes that say that they will expire in the licensee's birth month. So then rather than recommend that every statute be amended, we've recommended this language so that that conflict could be
I see.
ignored.
Okay, so we're going to leave it in. Okay. Thank you.
That Mr. House, is that your suggestion?
I mean, if we could do another 100-page bill next year too.
I'd really rather not.
So, no, one comment I do have though is under HB 518, we did change the definition of a license so that it comports with 541A in RSA 310. So we could probably just change the language to all licenses, and then we wouldn't need to identify registration, certifications, or all the other things. That would be my only suggestion on that piece.
Okay, all licenses, all right?
Yeah.
Okay,
Any-
so
Any other comments or questions?
I was going to say the rest of the bill, sections 6, 7, let me see here, 6, 7, and 8, kind of all go hand in hand. Section 6, we've made this recommendation in response to jail car committee concerns about the enforcement of expired rules. 541A is pretty explicit that agencies are not to enforce expired rules, but we have been encountering that a lot. And so we made this recommendation in response to that concern. So Section 6 would allow the court, Merrimack County Superior Court, if the court so chooses, to levy a financial penalty upon an agency for enforcing an expired rule. Again, that is if the court so chooses to do so. If the court was asked to issue a declaratory judgment on an expired rule. So, an expired rule is no longer law. It doesn't matter what the rule was governing. It can't be enforced. And like I said, we are encountering situations in which the rules have been enforced. The other two sections, 7 and 8, are also about the enforcement of expired rules. The 7 is around the refunding. It would require agencies to refund fines and fees collected on that expired rule. So, like I said, the statute is pretty clear that agencies should not be enforcing expired rules for any purpose. And so this would basically direct the agencies to refund any fees or fines that they collected on an expired rule. Section 8 would require the agencies to file an additional report. And they already have to file a report with their final proposal outlining stakeholder comments and how they considered those comments. So this would be, in addition to that report, it would basically outline what enforcement actions they have taken pursuant to the expired rule. And it would specifically require them to include whether or not any fines or fees were assessed and whether or not they have been refunded. So that, in an essence, is what these 3 sections are about.
Representative McGuire.
Yes, this is the question that the JLCAR has been asking on every rule that comes before them that was expired, and the agencies generally have the response. This change will simply put that response into the permanent record of the rule because it'll be part of the final package. And I think we need that regardless of any other issue we adopt.
Mr. Morrow.
Thank you. I would like to note that OPLC is, by and large, an exception to this. Frequently, when they come before JLCAR, they know that there's an expired rule, and they will look without asking by the committee whether or not it's been enforced, whether any fines have been imposed, etc. And they have even gone to the step of returning fees that were collected under expired rules. I would add that the underlying issue is enforcement of those expired rules. The process we've laid out here in 6, 7, and 8 may not be the best. There may be others that would work better, but it was just an idea how to address this situation.
And one other thing to note is that, the fines and fees are often not set by statute. The agency is directed to establish those in administrative rule. So if the rule expires, well, then there's no authority to collect those fines and fees. And Director Morrill is correct in that OPLC actually goes, beyond, what we normally see by the agencies, and that they often do come prepared to discuss that enforcement. And then they also, already go ahead and refund. So we were thinking that the impact might be minimal, but we don't know. And like Director Morrill said, there could be a better way to go about this, but this is what we recommended.
Sounds fair. Representative Schmidt.
Thank you, Madam Chair. There are several of course, as you know, are on the JLCAR currently. But for members of the public or other people who are not at the JLCAR meetings on a regular basis, the reality is that this expired rules situation is one that is very meticulously adhered to with regard to JLCAR meetings when an item comes up that relates to an expired rule. It is meticulously reported on it in every instance, and the chair generally questions what the agency has been doing on this rule, and the report is that we haven't been enforcing it, and it's. I just want to make sure that everybody that's not there on a regular basis knows that that this is being adhered to very meticulous is the right word, very meticulously, because we take it seriously that an expired rule is not a rule. It's a nullity. Thank you.
Any other comments? Thank you very much for your input. So at this point, I would ask Representative McGuire, as the prime sponsor and the purported sponsor of the amendment, if you'd be willing to redraft your amendment. It'll obviously take a renumbering with the deletion of section 1. Would you be willing to take that on?
The revised amendment will delete section 1, reword section 2 slightly to simply say all licenses, and I think that's the only other real change. Okay.
And then
And
I
of
think
course,
that'll
renumbering
require
and so
renumbering of the rest of your amendment. Thank you very much.
Yeah, we'll do it that way. Okay. Yes, I can do that.
Thank you. Is that all? Okay. I don't think we can actually vote on the amendment at this point, but does the subcommittee feel that we need to take a vote on the amendment, or are you okay with just presenting it at the next exec?
I think if we have the amendment and we can meet just prior to when we exec and do a quick vote to make it official.
Okay.
Yeah, I'm good with that, too.
All
I
right.
will distribute the amendment
Okay.
to
That's
the
what we shall
subcommittee
do.
as soon as I get it.
All right. Thank you. Do I have a motion to adjourn? Thank you.
Second.
Second.
Thank you all for your attendance and for your important submissions.
Right. So there will be an exec session starting at 1:30. We'll have a Republican caucus in here at 1. I presume there will be a Democrat caucus somewhere else.
I'm just asking too, do you have an idea what time the exec is going to be on the 13th?
We're starting first thing in the morning. I think it's 10 o'clock on we've already scheduled a couple of bills.
That's what's in the calendar, 10
It's in the
o'clock.
calendar.
Okay,
Yeah.
so we'll put the subcommittee like 9:30 or something to,
Something like that,
yeah,
yes.
thank you.
this is our executive session on about half the remaining bills. I will not be going in order. And committee reports are due as soon as possible and no later than 10 o'clock Monday morning at the latest. So if you're writing a report, that's your deadline. Okay. And we have, I think Representative Grote is still talking to OLS about her amendment. And Representative Gerhardt's not here. Okay. So I'd like to start with House Bill 1387 on the State Building Code. And I move ought to pass and present amendment 0813H.
Second.
Okay. You should.
Yes,
It
you
was
do.
passed out. It's a very short one. We wouldn't want that to happen to you. Or the snake. All right, so I'll mention this amendment simply changes the timing for when the Building Code Review Board updates, starts review of a code. It was set at 2 years, and this amendment makes it 1 year because we now require legislative confirmation of the changes before they go into effect. So this is wait a year, have it reviewed, and then have it approved by the legislation. And it's going to be at least 2 years before you get through that process. So this simply allows the board to start their review a little sooner on some of them. It is essentially the same effect as current law, and I hope you will support it. Representative Goldie?
I think well said, and I think that was actually asked for too by the board as well.
You're right, it was. Yes,
Madam Chair,
yes.
I'll just add, as chair of the subcommittee, this was requested by the board and very simple change. The committee was in agreement, but we did not have the amendment before us. So the subcommittee is in favor of it, but we did not vote on it. Thank you.
Okay. Anyone else have comments, questions about the amendment? All right, seeing none, the motion is to adopt amendment 0813H to House Bill 1387, and the clerk can call the roll.
Representative Simon.
Yes.
Representative Lakes.
Yes.
Representative Bailey.
Yes.
Representative Santo Sasso.
Yes.
Representative Dolan.
Yes.
Clerk votes yes. Representative Boyd.
Yes.
Representative Brown.
Yes.
Representative Grote.
Wasn't here when the question was called.
Yes, you were.
Yes.
You weren't here when the motion was made, but you were here when the question was called.
Good, yes.
Representative Schmidt.
Yes.
Representative Goley.
Yes.
Representative Schuett.
Yes.
Representative Selig.
Yes.
Representative Davis.
Yes.
Representative Lane.
Yes.
Representative Gould.
Yes.
Representative Smith.
Yes.
Representative Mangiapudi.
Yes.
And the chair.
Yes.
19 yea, 0 nay.
Okay. And I move ought to pass with amendment for House Bill 1387.
Second.
Okay, I have nothing more to say. This is a minor technical corrections to the process of updating building codes. Representative Goldie?
Well said.
Okay. Anyone else have comments, questions, concerns? Okay, seeing none, the clerk can call the roll.
Representative Simon.
Yes.
Representative Lakes.
Yes.
Representative Bailey.
Yes.
Representative Santo Sasso.
Yes.
Representative Dolan.
Yes.
Clerk votes yes. Representative Boyd.
Yes.
Representative Brown.
Yes.
Representative Grote.
Yes.
Representative Schmidt.
Yes.
Representative Goley.
Yes.
Representative Schuett,
Yes.
Representative Selig,
Yes.
Representative Davis,
Yes.
Representative Lane,
Yes.
Representative Gould,
Yes.
Representative Smith,
Yes.
Representative Mangiapudi,
Yes.
and the chair.
Yes.
19 yea, 0 nay.
All right. Does anyone have any objections to consent? All right, we'll put that one on consent. All right, moving on to something more interesting. Okay, Representative Mangiapudi, you have a motion on House Bill 1285.
I move to ITL 1285.
Okay, is there Representative Lekis seconds? Do you wish to speak to your motion?
Thank you, Madam Speaker, sorry. Madam Chair. This makes more sense not to do it right now with all the podiatry meets once in 3 months. And the Board of Medicine meets every month. So to add more to the podiatric member of the board to meet every month doesn't make sense, and it's functioning well. If it ain't broken, don't fix it. So that's, with that, I say we don't merge.
Okay. Representative Lekis?
Yep. I agree. The other point is that it's not clear they would fit together too well. I mean, the doctors, the podiatrists have some conflict. There is an issue that there aren't that many podiatrists, so it is a small profession. It might make sense in the future to turn it into an advisory board, but doing the merger, I don't think is the right answer.
Okay. Representative Schmidt, you have a comment? Nope.
Just, I agree that it's not appropriate to merge these two boards.
Okay, excellent. Anyone else? Okay, the motion is inexpedient to legislate on House Bill 1285, and the clerk can call the roll.
Representative Simon,
Yes.
Representative Lakis,
Yes.
Representative Bailey,
Yes.
Representative Santonastasso,
Yes.
Representative Dolan,
Yes.
Representative Gerhard,
Yes.
Clerk votes yes. Representative Boyd,
Yes.
Representative Brown,
Yes.
Representative Groda,
Yes.
Representative Schmidt,
Yes.
Representative Goley,
Yes.
Representative Schuett,
Yes.
Representative Selig,
Yes.
Representative Davis,
Yes.
Representative Lane,
Yes.
Representative Gould,
Yes.
Representative Smith,
Yes.
Representative Mangiapudi,
Yes.
and the chair.
Yes.
20 yeas, 0 nay.
Okay. Any objections to consent? Okay, seeing none, we'll put that one on consent. All right, and I'm going to move inexpedient to legislate on House Bill 1190. Is there a second?
I'll second.
Okay. And this is the Interstate Social Work Licensure Compact. It's well-intentioned, but I'm convinced it's unconstitutional, and therefore I can't recommend it and I can't vote for it. Representative Simon?
Yeah, for those reasons, I also had some concerns about the dynamics that might create state to state. And it didn't seem like it was going to help some of the concerns that were being brought forward by the social workers as well. I just, as a general rule, I have a problem setting up these quasi-governmental agencies that have the power to somewhat oversee themselves. And the fact that they could pass a law that's binding on the state of New Hampshire, that we would have to be reactionary to, that we wouldn't have say on that before it went into effect, but we would have to react to it, to me, I think is also unconstitutional. So for those reasons, I can't support it. I agree, though. The concept is fine, but I can't agree with the compact itself.
All right. Anyone else? Representative Mangiapudi?
I will not be voting ITL on this. I think it's a critical piece at this point when you're facing so much shortage with mental health providers. And it's before the COVID itself, we had the mental health crisis, and it was overshadowed by the pandemic. And now we are facing it even more. So to say this is not, it's not the answer for everything, but at least it is the right, one of the tools that can be in the toolbox for mental health providers. So I cannot support the ITL this.
Okay, Representative Lekis?
I agree with the other person made the motion and seconded. The only thing I'd say is that, I mean, it's too bad it's structured this way. If it was done in a way that the board of the compact could propose rules, but they would not go into effect until ratified by the legislatures that wanted to, or the states that wanted to, I would have been fine with this.
Okay. Anyone else? Representative Smith?
Thank you, Madam Chair. Just a thought. Right now, we do have critical shortages in the areas that we're talking about. Could this be timed? Could there be a set time for this to work? And then it has to be relooked at, and at that point, could be ITL'd or tabled or whatever, and not go any further. Could we set a time on this?
Unfortunately, it has to be voted out of this committee by the end of the month. And this isn't quite at the deadline, but it's not far
close.
from it.
Okay.
And the other point is that a feature of these compacts is that every state has to adopt the exact same language. We can't modify it.
Okay. All right. Thank you.
Okay. Representative Goldie?
Thank you, Madam Chair, and I too will support the ITL. One of the main reasons, like you said, is boilerplate language. I don't think we should have to follow that and be held to it. Second is, when we heard in testimony from all the social workers that they'd be able to follow their patients from state to state. We heard in testimony only Missouri and South Dakota haven't enacted legislation so far. So they would not be able to follow from state to state unless another state also got into the compact. Another reason for this is the compact has not yet formed, and until the compact forms and puts its rules in place, I think it's not appropriate for New Hampshire to jump into that compact not knowing what the rules are. When the compact is formed and the rules are in place, then we can look at it and we can go forward. But I don't think it's fair for everyone to come here saying we should jump into a compact as a state of New Hampshire not knowing those rules. So for that reason, and until it's formed, I cannot support this. And for one other reason, in which is unfortunate in this boilerplate language, one of my big sticking points still remains, just like in all the other compacts I voted against, is the ability to lease, purchase, retain, own, hold, improve, or use any property, real, personal, or mixed. Sell, convey, mortgage, pledge, lease, exchange, abandon, or otherwise dispose of property or personal mixed. For those reasons, I mean, in a compact, until that boilerplate language is removed, I mean, we're signing up for something we don't even know what kind of property we're talking about purchasing. Thank you.
Okay. And Representative Broder?
So as you can see, there's a lot of mixed feelings on this issue, but I'll be voting against the ITL because joining the compact allows New Hampshire to be part of that rulemaking process and to be part of that. And if it chooses at one point not to belong to the compact, it can withdraw at any time. So for me, I'm going to be supporting I won't be supporting the ITL, but I'm sure that it will be supported by the committee, and it is what it is, and people should vote their conscience.
All right. All right. Representative Mangiaputi?
Thank you, Madam Chair. I also want to bring to the attention compact, yes, once it's formed, then it's not the core group that's making the rule and setting the compact up. So if you want to be at the table making or shaping this compact, the time is now, I think. And that's why I cannot support the ITL.
Okay. Fair enough. Representative Brown and then Simon.
Thank you, Madam Chair. I would echo what Representative Goldie said to my right and follow up on Representative Groda. I think the withdrawal has to be done legislatively here at the House, and it says 180 days after the enactment of the repealing statute is how long it takes to withdraw. So I think that's kind of a long time.
Okay. Representative Simon and then Gould.
Thank you, Madam Chair. Yes, to Representative Manjaputi's point, I understand the point that's being made. However, my concern would be just being at the table to be able to set the rules does not mean that we would get the rules that we want. We could have input into them, but we could be outvoted by the other people who are in charge, and then we would be committed to the compact at that point without knowing what those rules are going to be and what they look like, to Representative Goldie's point. So I would still have a bit of a concern with that, even though we would be at the table.
Representative Gould.
Clearly, we have some division in the committee on this one. We can't all agree on everything. Having heard all the testimony and having gotten so many communications from social workers supporting this, knowing the crisis we have in our state and knowing that 180 days to withdraw isn't the end of the world, and a compact is not likely to do anything that would be harming to the public in those 180 days. And knowing that the Office of Professional Licensor supports this, it just is a no-brainer for me. I'll be not voting ITL.
Okay. Anyone else? All right. The motion is the next meeting to legislate on House Bill 1190, and the clerk can call the roll.
Representative Simon.
Yes.
Representative Lakis.
Yes.
Representative Bailey.
Yes.
Representative Santonastasso.
Yes.
Representative Dolan.
Yes.
Representative Gerhard.
Yes.
Clerk votes yes. Representative Boyd.
Yes.
Representative Brown.
Yes.
Representative Groda.
No.
Representative Schmidt.
No.
Representative Goley.
Yes.
Representative Schuett.
Yes.
Representative Selig.
No.
Representative Davis.
No.
Representative Lane.
No.
Representative Gould.
No.
Representative Smith.
No.
Representative Manjapudi.
No.
And the chair.
Yes.
12 yea, 8 nay.
All right. Motion passes 12-8. I don't think that qualifies for consent. So, does someone wish to write a minority report?
Gladly.
All right, Representative Broda will write a minority report. Okay. And on a more collegial note, all right. On House Bill 1486, Representative Broda.
Yes, I reluctantly move a ITL on House Bill 1486.
Is there a second?
I'll second.
Representative Gould was first. All right, do you wish to speak to your motion?
Yes, the subcommittee met and we did have an amendment that would have changed the bill from a requirement to a data gathering position within DA, within the department. And when we spoke to Mr. Arlinghouse, he didn't have a method to do that, but he was certainly willing to discuss it. And after the emails that we received recently, which obviously seemed to misunderstand the whole purpose of what we were trying to do, at this point, I think it's better if we just, and I've spoken to the sponsor of the bill, if we just ITL the bill and try a different way at a different time.
Thank you. Representative Gould?
No more to add to that.
Representative Schmidt?
Thank you, Madam Chair. Well, I think one of the things that's eminently clear with regard to the current situation is that this committee does not understand this bill or this concept well enough to make a contribution other than saying, this doesn't seem to work, so we're going to ITL. I'm not saying that's an irresponsible thing to do, but I think that the reality is that carbon pricing is coming to the world, and it's coming here as well. It would be better to do it at the national level, clearly, but I think the correct, better motion would be interim study so that we can get to understand the bill better. Thank you.
And then Representative Blackus?
Thank you. I agree with what's been said. The only thing I'd add is that I think, trying to use the procurement process to achieve goals, from any perspective is really not the best thing to do. Let's leave like the retirement system, let's leave the procurement process to try and get the best deal for the taxpayers in New Hampshire. And if there's something that needs to be done in an area, then that should be handled as a separate matter, not enforced through procurement.
Okay. Anyone else? Representative Simon?
Thank you, Madam Chair. I'll be supporting the ITL, but to Representative Schmidt's point, I will be voting ITL, understanding the proposal and the concept of the bill, but finding the methodology faulty. It mixes economic structure with social sentiments. And when the social sentiment is basically the foundation of the model, it's not a purely economic system. So I was unable to get anybody to explain to me how we were going to come out with any kind of accurate data or accurate information. And it was kind of like, well, some estimates better than nothing. But I don't necessarily think that's true. I think if you make the estimate in the wrong direction, you're going to get farther away from the truth and not closer to the truth. And you could end up making very poor decisions that would have real implications for the state. So until we could come up with some sort of system that could accurately measure what the carbon cost would be, I think it would be irresponsible on our part to push a piece of legislation like this forward.
Okay. Anyone else? All right, the motion is inexpedient to legislate on House Bill 1486, and the clerk can call the roll.
Representative Simon.
Yes.
Representative Lakis.
Yes.
Representative Bailey.
Yes.
Representative Santo Sasso.
Yes.
Representative Dolan.
Yes.
Representative Gerhard.
Yes.
Clerk votes yes. Representative Boyd.
Yes.
Representative Brown.
Yes.
Representative Groda.
Yes.
Representative Schmidt.
No.
Representative Goley.
Yes.
Representative Schuett.
Yes.
Representative Selig.
Yes.
Representative Davis.
Yes.
Representative Lane.
Yes.
Representative Gould.
Yes.
Representative Smith.
Yes.
Representative Mangiapudi.
Yes.
And the chair.
Yes.
19 yea, 1 nay.
Okay, motion passes. Representative Schmidt, do you object to consent?
I'm okay with consent.
Okay, does anyone else object to consent? All right, seeing none, we'll put this on consent. All right. House Bill 1271, Representative Blackus, you have a motion?
Yes, I do. It's ought to pass with amendment, and let me find the amendment number. Amendment 0850H.
Would you repeat that number for those of us with
Sure.
bad hearing?
0850H. And it was handed out. People should have it.
Aha, it's a thick one.
Yeah, it is.
Okay,
Yeah, we had some fun with this one.
okay. Is there a second to that? Okay, that's Blackus and Gould. Do you wish to speak to your motion?
I do. First, I'd like to thank everybody in the subcommittee for doing an awful lot of work on this thing. So, make sure I am getting the right, okay. So this bill was to convert a number of boards from regulatory to advisory boards and to combine a couple of boards. And so first, the combination was combining the already advisory board of massage therapists with the advisory board of reflexology, structural integration, agent body work. And that was at the request of those boards. They deal with some similar issues, and so that was what made sense. The rest of the boards that were converted to advisory boards were all boards that had relatively few licensees, and so there were the usual concerns about a small number, market participants, regulating a small number of licensees, and there were antitrust and other concerns there. What we spent a lot of our time on was going through and closely examining the makeup of each one of the proposed boards, because I think when the bill was drafted, it just hacked them all down to 3, and that didn't seem appropriate to us in all cases. So we took a close look at that. And then there was some general cleanup, similar things that have been dealt with in other bills, where there was authority left with the board and OPLC, and some language changes in similar areas. But that's the core of what we're doing. And just one example is the Board of Midwifery. There's a total of 33 licensed midwives in the state. And, the 3 that were on the board, made up almost 10% of all the practicing midwives, and that's problematic. But we did look at that one, and the midwives were not happy with the proposed makeup of the board. And we did expand it from 3 to 5 and added back in 3 midwives and 2 doctors in particular specialties they wanted. So we did look at their concerns.
Okay. Representative Gould?
I would just add, thank you, Madam Chair, and thank you, Tony Leckis, Representative Leckis, for all your work and leading us in the committee work. I know the midwifery people were happy with some of the gains in the amendment, I'll say. So I think the committee worked really hard to try to listen to the concerns and find the most common ground and touch a happy medium note. So that's about all I have to say.
Representative Mangiaputi?
Thank you, Madam Chair. Having served on the subcommittee, I still have concerns about the transition of all the boards that are listed from statutory board to advisory. And I agree moving in that direction, but at still this time, last year, the whole changes that have happened that has not been implemented to make more changes on top of it, I am very skeptical about it. So I do have a hard time supporting the OTPA for, I put in the hours with the subcommittee, and my question always lingered that. So I still feel strongly that we're not there yet.
Okay. Representative Beretta?
Having spent my life in the last 2 weeks with the amendment to 1095, I can tell you that the language in this bill conflicts with what we have in that amendment. And so we need to take a look at that. And I'm not even sure if I have the brain power right now to do it, frankly. So I think that we need to align these before we accept it. So maybe what we want to do is spend the next week doing that, since I'll be doing that with the amendment to 1095. I just don't want to have more problems.
I really appreciate that, because that makes a lot of sense. The other thing we could do is accept this amendment and then change 1095, which is already being changed all over the place, to include it. But or we can choose to work on the 2 of them together. Yes, Representative Gould, and then, yes, I see.
Thank you, Madam Chair.
Yes, I know.
Thank you, Madam Chair. And to Representative Grota, is the difference, the inconsistencies you're talking about regarding the authority to do things to the executive director versus the authority to do things to the office?
Well, that's one. And this is the first time I've looked at this, so I just want to make sure that I don't miss anything else. But in all of the other legislation that we've looked at, we have not used as executive director. We've used office. And I don't know if I just would like to have I want like some harmony to this, because one of the issues that I didn't have before, but I have now, is that when we touch something in OPLC, we touch 25 other things that we don't even know we've affected. And it is extremely difficult, because then we end up with 122 pages that we have to literally go line by line, word by word. Now, maybe that's okay, you know, but when only one person is doing it, or two people are doing it, it's a heavy burden for that person on top of everything else that they do. And I don't want to cause further kerfuffles for the committee. I want us to, you know, have a relationship that is, I know among our peers, we are on the same page. But to me, our relationship with OPLC, our relationship with the Office of Legislative Services, our ability to speak about this coherently on the floor of the House are all important.
Okay, Representative Blackus.
I understand and really sympathize with the concerns. I mean, I'll leave how we deal with this up to the chair, but if the decision is to work together on it, I'd be glad to do that.
Thank you, Tom.
Representative Goldie, I'm sorry to have skipped over you.
Thank you, Madam Chair. And I too agree with Representative Grota, as this same content is in two specific bills we have before us. And while it may have been a chuckle from the attorney OPLC to talk about another 100-page bill coming forward, I'm looking down the road that the real possibility is there, and it's starting to get out of control. They need to start to work on areas that they really want to change, come forward with bits and pieces, and not 100-page amendments on changing big pieces of law that are doing different sections at a time. I mean, it bothers me that we're here doing this at this short a notice. And I know we worked on trying through the process to get it done in a timely manner. But in the way I look at it, what we had before us earlier today, and I know we're not there, but this is part of that, should have been in front of us in January to have a full 2 months to review that and not 2 weeks. But I'll speak to the amendment in itself and some of the reasons why I'm opposed to it. First is the first section, and I'm not sure why it's even in there, the purpose statement. Provide supervision over regulatory bodies comprised of active market participants. I don't know why that's needed. Second is, we'll go down to line 18 on this, explaining what OPLC and the director have the responsibilities to do. And the statement as the rules in effect upon the effective date of this section shall remain in effect until repealed by the executive director. I don't even know why that needs to be in statute.
Because if you change the statute, it tends to invalidate the rule. We don't want to invalidate any rules, but unthinkingly. That does need to be there. And you'll notice that's in many different sections. That is important.
And I still have the floor, so I'll continue on. And as I've just seen this, give me a minute as I go through this, looking at the points I had brought forward.
Ask her.
I'll stop for now and I'll come back when I find the section I look for.
Okay, thank you. I appreciate your thoroughness. Representative Blackus?
Yeah, I'll just comment on the purpose part of it. If you look at it, the purpose part, which is all through this, for each one of the boards, there was certainly stuff in there that I thought was unnecessary and some people had an issue with. And the amendment does remove most of it. Maybe there's more that could go out, but I removed all that people who were involved had an objection to. So tried to accommodate that.
Anyone else? Representative Simon?
Thank you, Madam Chair. I am just curious, and I believe Representative Grote brought it up, the reference to the executive director. I know, and looking at the other pieces, we haven't used that language. It seems like the only place that we're using that language. I just don't know if that should be of concern to the committee.
Okay. Representative Blackus?
Yeah, in the bill as originally drafted, it used that language in some places and used office in the other place. And if I recall correctly, maybe somebody else in the subcommittee can correct me, but we asked that of the executive director and Attorney Osterhout, and that's what they recommended. And I hadn't had a chance to look at your 112-page monstrosity, so that you got saddled with. So
It says office.
what?
It says office,
yeah,
and I went page by page, line by line, with the executive director and Mr. Ost, and no one said a peep
yeah.
about executive director, which is a little bit.
Yes.
I don't want to get too much, but but the reason we brought it up was because in some places in the bill it did one thing and in some places did the other, and that's why the issue came up for ours.
Representative Gould?
Yeah, I just wanted to reinforce that a couple of things that have been said here. One is that my colleagues who have recognized that we've done an excruciating amount of work on some very intricate bills on licensing, and so I just think some of this is inevitable. But specifically on this topic, it came up. I believe it was Representative Mangiapudi who pointed out that she was really bothered by the inconsistency, and then the office clarified that. The office, the executive director and the attorney of OPLC pointed out that it takes an individual to take action, that an office really can't. So that in a legal, technical sense, it should be the executive director throughout. And so I know we talked about it, the inconsistency that we were seeing with some of these other bills. I just think the bottom line is that I support 100%. Let's take another week and see what we can do to iron out some of the inconsistent language.
Yeah, I'm rather disappointed to discover that large portions of this bill are duplicative to sections that are in the amendment to 1095. And I think that we ought to, when looking at it, we ought to put the sections in either one or the other, but please not both. It makes things much easier for everybody. And so in light of that, I think we will recess this executive session.
Thank you.
Look at the language and make sure it is not duplicative or conflicting with House Bill 1095, and we hope come up with clean amendments on both of them. Yes.
So we're not up against the deadline yet, are we?
This bill must be voted out of committee by the 21st. I'm recessing this until
I
next week.
understand, but I think this is a very wise decision on your part, Madam Chair. The thing is, if we're not up against the deadline, we can do, there's a lot of work that's been done. I haven't been involved in most of it, but let's do just a little bit more and get it. It's not quite as, this is not commensurate with the kind of work product this committee ordinarily produces yet. So let's try and make it better.
And I think it might make sense to look at it and take some sections out of one bill and make sure that we don't have duplicate sections. So Representative Blackus and Grote, you'll schedule some additional work sessions. All right, we will recess that one. Let's get something simpler. Okay. All right, on House Bill 1059, I move ought to pass with amendment. Where's the amendment? Amendment 0804H.
I'll second that
1059.
amendment. I'll second.
Okay. It's 0804. With the amendment. Okay. It's my, okay. So, as recommended by the subcommittee, this amendment simply includes Building Code Review Board amendments approved as of January instead of November, because they had a few more minor ones, which were sent to the committee, and then made the effective date July 1st for simplicity, and that's the new fiscal year, just to give it a fixed date for convenience. This was the recommendation of the subcommittee. And Representative Brodick?
I have nothing else to add. Thank you.
Okay. Anyone else? Comments, questions? Representative Simon?
Thank you, Madam Chair. Could you just remind me the purpose of the striking out of 12 through 14?
That's not a change in the amendment.
It's not, okay.
That's in the bill itself.
It's in the original bill, right?
Yes.
Yep.
And it, I think it's covered elsewhere.
Okay.
Representative Mangiapudi?
Thank you, Madam Chair. My question, I don't know who can answer, but I'm confused as to, there's another building code bill, I believe, right? With the clean energy, or this is the one that was the energy portion of it, energy conservation code is part of it. Okay.
This bill references but does not update the energy code. We had an amendment that we discussed at the hearing and we discussed in subcommittee and decided not to accept. Do you wish to know why?
No, so that clarifies my question as to that the energy portion is not part of it. So
The
okay,
energy
if you
portion
have
is not included
okay,
because we were convinced that it had too many unintended consequences, and it had also increased the cost for homes in particular, much more than would be worth it.
can I follow up?
Please.
Ask you another question. The energy for commercial, meaning anything over 4 units for residential would be considered commercial, correct?
Not exact. Residential is no more than 3 stories. I think it's in some size limit, which I forget. And so a small business could be covered under the residential code. More than 4 stories is commercial by definition, and over, I forget how many thousand feet, 5,000 I think, is commercial. We asked about incorporating the commercial energy code, but we are not skilled enough to do that ourselves, and the people that are skilled enough couldn't come to an agreement on how to do that.
Okay.
So better not to try and split it than to do it really badly, which is how I guessed the subcommittee would do it.
One last one.
Yeah.
So my concern with that is that with so many housing crisis, 150 unit complexes, workforce, you name it, market rate, workforce, low income housing, all those things coming up, not having a clear understanding of where this, where we stand with the energy efficiency and conservation coming up from ground up would be a detriment, because retrofitting these buildings would be more costly than coming up. And on the same token, with passing this, we have an option to see if there's a way to do something at the floor, or amend it at the in the
Yes,
floor
yes.
or in Senate.
Absolutely.
Okay, great. Thank
Anyone else? Representative Schuett.
Thank you, Madam Chair. Both in the committee hearing and in the subcommittee hearing particularly, we heard a lot of pro and con regarding the energy portion. The fact of the matter is that I think the mood of this committee is that we do need to adopt updating the building codes for right now. And that's where this amendment with this bill will take us. If we feel that we need to update the energy portion, we will look at that going forward. Thank you.
Okay, anyone else? Representative Brown?
Thank you, Madam Chair. I want to speak to the energy portion, but in the discussion going ahead, shall I wait?
Oh, no,
It's not really relevant to the amendment specifically.
that's okay. That'll simplify the discussion of the ought to pass motion.
Okay. So obviously we've all received a lot of information. I think it would be my suggestion for everyone in the committee to look at one of the emails that sent us the 2021 IECC and the energy appendix for that. No one discussed this when they proposed the IECC going to 2021. In the energy appendix, and I've looked at this and I've done a little other reading, so it's my interpretation. It says specifically that this appendix will allow jurisdictions, towns and or cities to require residential building to be net zero energy, meaning you have to produce as much energy as you use in your house, and your jurisdiction can do that within the time frame that they choose. So if we were to pass the 2021 IECC, no one mentioned this appendix, which can put a pretty serious cost on residential housing in separate communities, if I'm reading it correctly. Thank you.
Thank you. Other comments? Representative Mangiapudi?
Sorry, Madam Chair. Yes, net zero there are a couple of definitions of net zero in terms of trying to see it's not the energy produced, it's the passive energy efficiency, conservation, and usage to reduce the carbon footprint. And that also qualifies as net zero. And I think by adopting 2021 building code, that will give us the opportunity to see how that can be done in the new constructions, especially the mega buildings or all the new upcoming one to be done. So if the building code is already, if this is adopted, it will help with bringing that energy and climate code into being. If this passes, it will enable that. I think that's my understanding. I could be totally wrong, but that's my understanding.
Thank you, Madam Chair. As someone that works on job sites and builds houses daily, well, except for Saturday and Sunday mostly, I think a lot of these building codes are just excessive and unnecessary. We talk about lowering the cost of housing, but I mean, on a job right now up in Molten Borough on Squam Lake, one of those multi-million-dollar houses, but the excessive, the extent that they make you go to secure just a 3-story tower with these concrete foundations, it's really absurd. And if you really want to get an idea of what's going on, you should go to these job sites and talk to these high school dropouts that are working on these job sites and building houses. They know much more than we do. And as far as the energy conservation stuff goes, a house, okay, just real quick, up in Sandwich, working on a barn. The sill plate needed to be replaced. This thing has been standing since the late 1700s. We're making these houses airtight right now, which is not helping anything. They're rotting from the inside out. And the plywood, if you look at it, it's all stamped exempt from formaldehyde regulations. So anyway, point being is we're making these toxic boxes that are airtight that if you look at when you put in doors and windows, it actually tells you that the houses have negative pressure now. It's actually sucking in water from the outside. So anyway, people need to breathe, houses need to breathe, and I think a lot of these energy conservation things, they might mean well, but I don't think they actually have common sense put into play. So that's all I'm going to say. I think you should talk to people building houses. Stop over one time when you see somebody and just talk to them. I think you might learn a few things. So thank you.
Madam Chair, I
Yes.
just have to, I am in that consulting business of building net zero communities and buildings and that whole efficiency, energy, and I'm not talking from just theoretical knowledge. So I do understand the codes and the green and passive buildings that are coming up, and New Hampshire is way behind it, but that's not my point. It's happening whether we like it or not across the nation, across the globe. And so the more we adopt and look at it preemptively, it's not this whole monstrosity of energy efficiency and climate change is a cost to the ratepayers is really not based in reality. So that's my 2 cents. So I just want to make sure that I'm not speaking from just theory and things. So I just wanted to bring that to attention. Thank you, Madam Chair.
And I'm sure that from that, you are well aware that the owner of the project can request settings that are vastly exceeding what the building code requires. And that's what point that I want to make. The building code should be the minimum necessary for safe buildings. And the builders and the owners are entitled to add additional requirements all they want. And many of them do. Representative Brown.
Thank you, Madam Chair, for letting me flog this a little bit more. To your point, building code should be for safety, to make sure our buildings are constructed properly for people's safety. If you read this appendix, here's what it says about the 2021 IECC. About 300 cities and counties and 10 states are signatories to the We Are Still In commitment supporting climate action to meet the goals of the Paris Climate Accord. And over 150 cities have committed to using 100% renewable energy. More are joining all the time. The Building Energy Code is an important policy tool for jurisdictions as they pursue these types of goals. That is not about safety. That's about climate change.
Thank you, Representative Brown. Any other comments? Okay, not seeing any. The motion is to adopt Amendment 0804H, and the clerk can call the roll.
Representative Simon.
Yes.
Representative Lakis.
Yes.
Representative Bailey.
Yes.
Representative Santos Sasso.
Yes.
Representative Dolan.
Yes.
Representative Gerard.
Yes.
Clerk votes yes. Representative Boyd.
Yes.
Representative Brown.
Yes.
Representative Groda.
Yes.
Representative Schmidt.
Yes.
Representative Goley.
Yes.
Representative Schuett.
Yes.
Representative Selig.
Yes.
Representative Davis.
Yes.
Representative Lane.
Yes.
Representative Gould.
Yes.
Representative Smith.
Yes.
Representative Mangiapudi.
Yes.
and the chair.
Yes.
20 yeas, 0 nay.
All right. And I'll move ought to pass with amendment on House Bill 1059.
I'll second.
Okay. I think we've said it all. Representative Broder? All right. Does anyone else have something to add? Yes, Representative Gould.
Just quickly, I'll say I will support the ITL on this, but I will look forward to if an amendment comes forward on the floor to add the energy code back in, because I would say that a destroyed planet is not very safe for people to live on. Thank you.
Thank you for that.
No, the
Any
ITL
other
is-
comments? Representative Dolan?
Oh.
Yes.
I know she made a mistake. She meant she's not voting yes on OTPA. Okay, that's what she meant.
All right.
All right. I figured that
Thank you
was-
for that clarification, because I thought I knew what we were doing until I heard,
That's okay. All right.
oh,
So,
we shall all hang
anyone
together.
else? We shall all hang together indeed. So the motion is ought to pass with amendment on House Bill 1059, and the clerk can call the roll.
Representative Simon.
Yes.
Representative Lakis.
Yes.
Representative Bailey.
Yes.
Representative Santonastasso.
Yes.
Representative Dolan.
Yes.
Representative Gerhard.
Yes.
Clerk votes yes. Representative Boyd.
Yes.
Representative Brown.
Yes.
Representative Groda.
Yes.
Representative Schmidt.
Yes, I think.
Representative Goley.
Yes.
Representative Schuett.
Yes.
Representative Selig.
Yes.
Representative Davis.
Yes.
Representative Lane.
Yes.
Representative Gould.
Yes.
Representative Smith.
Yes.
Representative Mangiapudi.
Yes.
And the chair.
Yes.
20 yeas, 0 nay.
Okay, motion passes 20-0. Does anyone object to consent? Representative Mangiapudi
Yeah,
objects to consent. We'll put it on the regular calendar.
Thank you.
No trouble. All right. We are moving right along. Another quick one. Representative Goley, do you have a motion on House Bill 1606?
Sure. I move inexpedient to legislate.
Is there a second?
I'll second.
Okay. Representative Goldie, you wish to speak to your motion?
Yes, I think during the testimony, we heard from Director Goulet that this is already being done and in the process of being done on as many web pages as they can going forward. So I feel that this is not necessary. I think it's been made loud and clear that this should be a priority, and I think he understands that. And with that, I'll leave it at that.
Representative Broder, do you wish to speak to your second?
Yes, thank you. During the testimony, we did hear the Department of Information Technologies is working on a consistent design for web pages for the state agencies that includes that information, and therefore it's already being done, although it's an excellent idea.
Okay. Anyone else? Representative Schmidt?
Thank you, Madam Chair. Well, I think there is some argument for some individuality. I think to the degree that our web pages have a certain uniform look, so that the public who doesn't deal with this every day, when they go from one page to another, at least have some idea, which side of the road they're going to be driving on, so to speak. So I think that this is probably the way we ought to go. Thank you.
Anyone else? Yeah, I'd have to agree that this is the way we ought to go. And I plan to start checking a few websites after they've had a chance to put the new ones up and make sure that the contact button is right up there. But I think they got the point. Representative Brown?
I would, as the sponsor, as you all know, I'd say thank you for your consideration. I agree, and at least it got them off dead center and moving what we think is in the right direction. So thank you all.
Okay. Anyone else? Okay, the motion is inexpedient to legislate on House Bill 1606. And the clerk can call the roll.
Representative Simon.
Yes.
Representative Lakis.
Yes.
Representative Bailey.
Yes.
Representative Santo Sasso.
Yes.
Representative Dolan.
Yes.
Representative Gerhard.
Absent.
Oh,
He stepped down.
I didn't, okay. Clerk votes yes. Representative Boyd.
Yes.
Representative Brown.
Yes.
Representative Groda.
Yes.
Representative Schmidt.
Yes.
Representative Goley.
Yes.
Representative Schuett.
Yes.
Representative Selig.
Yes.
Representative Davis.
Yes.
Representative Lane.
Yes.
Representative Gould.
Yes.
Representative Smith.
Yes.
Representative Manjapudi.
Yes.
And the chair.
Yes.
19 yea, 0 nay.
Okay. Any objection to consent? All right, seeing none, we'll put this one on consent. And since we are moving right along, I'm suggesting a 10-minute break so we can stretch our legs.
Yeah.
He's not here yet. He's not here. There's Representative. Guess we'll have to do a different one. What's that? 1411, yeah, I was going to do 1408, but Cherry's not here. All right. Resuming our executive session, House Bill 1411, Representative Groda.
Yes, on House Bill 1411, Madam Chair, I move ITL.
Is there a second? Oh, I'll second it. Do you wish to speak to your motion?
Yes, thank you. You might recall that this bill was submitted to us because there was a constituent who had difficulty in paying with cash at state agencies, especially the Turnpike. And upon speaking to Mr. Arlinghouse, Commissioner Arlinghouse, and it seems that all state agencies take cash except for the toll booths on Spalding Turnpike, and it's highly unlikely that we're going to pay someone to collect cash there, but there are non-traceable easy passes that you can get that would allow individuals to use that. So I didn't think this bill was necessary.
I'd like to say that I spent some time talking with someone from the Department of Transportation about those toll booths. And there are at least 3 different ways you can set up a cash program. The simplest is that you will not, is just go through the tolls without paying. And once a week, go in and pay your previous week's tolls because you won't get charged a fee until it's at least 8 days. So you can, and they do take cash at the service stations, and there's one near the tolls in I think it's Dover. You could also get a transponder, an Easy Pass transponder, and set it up with cash. That will not, you can either get it anonymously or in your name, and that will save you 30% on the tolls, which will pay for the cost of the transponder in about 2 weeks if you're going through once a day. So, and there are other things you can do, but it's a little more difficult if all you'd have is cash, but it can be managed without extra fees. And I think that considering the cost of having somebody out there collecting the tolls, it's not worth reinstituting toll collectors to save a few people some aggravation. Because everybody else is going to be paying for the toll collectors. Representative Selleck?
Thank you so much. I just want to say, as someone who regularly drives the Spalding Turnpike and now gets to drive them much more efficiently because there aren't the cash lanes of the 2 lanes that we have, it's also become much safer because we're not having traffic that is driving, unfortunately, at excessive speed, suddenly braking from by 50 to 60 miles per hour in a matter of seconds and not necessarily efficiently. So streamlining that process, in my opinion, is best.
Representative Brown and go ahead.
Yep. Thank you, Madam Chair. So I'm in support of this, and although I would like to follow up on Representative Groda's comments after I'm done. Many of us probably in the House have not experienced or maybe even had exposure to a person who could only pay their bills by cash. Sometimes it happens. People are in a bad place. They have a bad credit rating. They have, in fact, as I have explained to others, sometimes you find out that people don't have a bank account and they can't get one because they've had such a difficult time with money. They can't get a bank account. They can't have a debit card, therefore. And a lot of these people work on a cash basis. They'll go to Walmart and cash their paycheck so they have cash in their hand. And then maybe they have to do money orders at Walmart to pay their bills. They don't have a checkbook. They don't have any way to do that. I think that it's important for us to consider that and say that everyone should have a chance to pay their bill as necessary. And as I said, from 1606, we're the state. We aren't a commercial entity. Commercial entities are trying to do everything they can to make money, to not have you call them on the phone or not have you pay cash and to do everything online. That's not who we are at the state. We're public servants. We're supposed to be providing service to the people that need it. So I think that allowing a person to have cash payments, I think, is necessary. That being said, the sponsor, as we saw at the hearing, the sponsor had never thought about the toll booths. That's something until it came up in a question that she hadn't thought about. And obviously, we can't restaff toll booths for the few people that can't pay cash, and that's an outlier on this, although there are some solutions. So that's kind of how I feel on it, but I'd like to follow up with Representative Grody. You talked to, thank you. And can you maybe elaborate a little bit more on what that he said about
Yes, he
everyone?
checked all the state agencies that deal with the public, and they all have the ability to take cash. So, and I hope that my expedient way of explaining that did not indicate any callousness towards anyone who would be in any financial position that would only allow them to, and that's their prerogative. I mean, they could be, some people only deal in cash. Okay. So I just feel that since it's available, it's not something that we need to direct agencies to do.
May I, Madam Chair?
Please
Sorry.
follow up and then Representative Schmidt.
Yeah, thank you, Representative Groda. No, I didn't think that in the least. That's not at all. Thank you.
Representative Schmidt.
Thank you, Madam Chair. Well, I recall like 50 years ago when I was working in Chicago in a patent law office, and we had every one of the patent attorneys had a girl. That's the way they called them in those days. They were overwhelmingly women, and most of them were very fine people. All seem to be very well educated. They all belonged to a particular European ethnic group, and every payday they took their paycheck and went downstairs to the bank. This was in the 70th floor of the Sears Tower. The bank was on the first floor. They went down and cashed our paycheck, and so forth. And I was kind of stunned at the idea that some people who were in the patent law business and on one end had people who were cashing their checks. I'm going like, all that money, all that wasted, so forth and so on. But now, 50 years later, the bottom line is we don't even think about it because we've all got a transponder, right? Or if we want one, anyway, because we're in the house. And the Spalding now is clean and green. You just get on at one end and you never stop again until your car runs out of gas. If you've got a car that still burns gas. So the bottom line is, but this was a little humorous interlude, I hope, but that we are also state representatives that have constituencies, and many of us are in small towns, or we're pretty close to the center of government in our town. So I suggest that we talk with them about how they deal with that situation, because the state doesn't want to put toll collectors back on the toll highways. That's not going to happen. But we have to be mindful of the fact that there are a lot of people out there that we probably don't even think about it, that are still paying cash for everything. And we have to, so let's talk with our local government and see how they deal with it, because it could be that we have to make some additional adjustments at the state level, because we can't push down on the 28A says we can't push things down on the towns, but let's find out how our towns, how our constituents are dealing with people who only pay cash. Because we need to know that, and this bill bangs us in the head with a larger 2x4.
No. Representative Gould?
Thank you, Madam Chair. And to Representative Schmidt's point, at the full committee hearing, I think I reported that I had gotten a parking ticket and didn't want my husband to know and tried to go into the Concord Police Department to pay cash, and they refused to accept it. I'm happy to report that very day that I reported that in this committee meeting, I went out and I had a parking ticket. And when my husband got online to pay it, he saw that you can pay cash at the Concord Police Department. So I do think we're seeing a return to municipalities accepting cash payments, and I just wanted to reassure you. But I like your point. We should all check in our own municipalities.
If I may, I mean, the thing is that it may not be something that the locality wants, but if, let's ask them how they handle it. And then if the people can come in and pay their state bill, state charge at their locality, the towns are all dealing with the state. So let's just find out more. I'm sure we can profit from more information.
Representative Schuett?
Thank you, Madam Chair. As someone whose late brother-in-law was exactly the person that Representative Brown was describing, could not keep a bank account, cashed his Social Security checks at Walmart. But even he, with his disabilities, learned about a place where he could get money orders. I think they allowed 3 a month. He and my sister paid most of their utility bills in cash, but the instances where he could not use cash, he would get a money order and send it to, or take it to whatever place needed to be paid. So there are ways that folks that have these problems can deal with things. It may be a matter of education, but I just wanted to point that out. Thank you.
Representative Gerhart?
Thank you, Madam Chair. What happened to having the toll booths take coins and then the little gate opens up and there is no person necessary? That's the first thing. And the second thing with this is, I think the bigger issue is anonymity, and the fact that people don't always want the government at all levels, especially the higher up level, knowing what you're doing with your money. So I think just the idea that if cash is legal tender, then it should be accepted everywhere. So, thank you.
Yes. And I will report that when I was at the Secretary of State's office earlier this week, filing a business application, the person at the next window was taking $50 bills out of his wallet to pay for his similar license. So they do take cash and checks, which is why I was there, because I didn't have a credit card for the business. So, yeah, the tolls are a specific case, but there are ways around it. Representative Bailey.
I'm inclined to. This had problems in toll booths, for example, but I would point out that what it says on all your bills, you can look in your wallet, says this is legal tender for all debts, public and private. The cash money. I believe it's already illegal to not accept paper money. That's why it's called legal tender.
No.
Well, there are places out there that will not take anything over a 20.
Representative Mangiaputi.
Thank you, Madam Chair. Just going back to the Easy Pass, there is a path where you can get prepaid transponder that you pay money ahead of time, and when you run out, you run out. So you can go refill it, and that is one of the options. And I had one of the constituents who did not want to pay. They got that, and what you talked about, Madam Chair, they were out of country or whatever for 2 weeks, so they had to pay penalty. They went through the toll, they got the thing, but if they had gone back and paid it within the week, there won't be any penalty, and it'll be mailed, and your car is registered anyways. So you can't hide the fact that where the registration is addressed to. So that is, if you don't want to go through toll, then you don't have to, but your registered car will go through that. So there are options, and, you know, it's just a matter of finding those options to work. Thank you.
All right. Anyone else? All right, we've all told our cash stories, and the motion is inexpedient to legislate. The clerk can call the roll.
Representative Simon.
Yes.
Representative Lakis.
Yes.
Representative Bailey.
Yes.
Representative Santo Nastasso.
Yes.
Representative Dolan.
Yes.
Representative Gerhard.
No.
Clerk votes no. Representative Boyd.
Yes.
Representative Brown.
No.
Representative Grota.
Yes.
Representative Schmidt.
Yes.
Representative Goley.
Yes.
Representative Schuett.
Yes.
Representative Selig.
Yes.
Representative Davis.
Yes.
Representative Lane.
Yes.
Representative Gould.
Given that so many are accepting cash, yes.
Representative Smith.
Yes.
Representative Mangiaputi.
Yes.
And the chair.
Yes.
17 yea, 3 nay.
All right. Do you think this should go on consent?
Madam Chair, it is a FN. It still can go?
It's not a large FN.
Okay.
Better not. You don't have to speak to it. All right, we'll put this on the regular calendar since there appears to be some concern. Does anyone want to write a minority report?
I will do that.
Okay, and Representative Brown will write the minority report.
Not a bad idea for the rest of the House to at least momentarily think about this. We heard these stories, and thought about it.
Okay, well, that's fine. All right, that's that one. Representative Bailey, you have a motion on House Bill 1272.
Yes, I'd like to move ITL on House Bill 1272 FN.
I'll second.
Okay. Do you wish to speak to your motion?
I understand there's a potential conflict or problem could be created in that this uses the term reasonably similar, which has the potential to conflict with existing things that say scope of practice, that have defined particular scopes of practice. And this would allow in things that are not, that must be called similar because they have the same name and perhaps are not similar.
Okay. Representative Broda?
I have nothing else to add.
Okay. No. I'd like to say that we passed a very broad reciprocity bill last year, and it is still being implemented in rules. And I think it's wise not to change the ground rules until we've finished establishing the basis for reciprocity. Anyone else? All right, seeing, yes, Representative Gould.
Having worked on the committee, thank you, Madam Chair, for those remarks. I agree. I think that was our findings, and yeah.
Anyone else? All right, the motion is inexpedient to legislate on House Bill 1272, and the clerk can call the roll.
Representative Simon.
Yes.
Representative Lakis.
Yes.
Representative Bailey.
Yes.
Representative Santo Nastasso.
Yes.
Representative Dolan.
Yes.
Representative Gerhard.
No.
Clerk votes yes. Representative Boyd.
Yes.
Representative Brown.
Yes.
Representative Grota.
Yes.
Representative Schmidt.
Yes.
Representative Goley.
Yes.
Representative Schuett. Sorry. Representative Selig.
Yes.
Representative Davis.
Yes.
Representative Lane.
Yes.
Representative Gould.
Yes.
Representative Smith.
Yes.
Representative Mangiaputi.
Yes.
And the chair.
Yes.
19 yea, 1 nay.
No objection to consent? All right. Fair enough. That means you're not writing a minority report even. Okay, good. House Bill 1408, Representative Gould, do you have a motion? Interim study, as far as I know.
Madam Chair, I move interim study for House Bill 1408.
Okay, is there a second? Second by Representative Lekis. Do you wish to speak to your motion?
I will, Madam Chair. The committee heard many concerns about the board mergers and many changes made last year with the Office of Professional Licensing. Some of the rules from last year's changes are just now getting finalized. The subcommittee worked on many changes for an amendment. We agreed in the end that it's not quite ready, but given a little time and a bit more work, it could address areas that need to be cleaned up for moving ahead.
Representative Lekis?
Thank you. I agree with that. And in addition, we had some concerns that there might have been stuff in here that would impinge on Representative Grota's amendment she's working on, which is one of the reasons we did interim study rather than ITL, because we didn't want to do something that would stand in the way of that.
How polite.
It's very decent.
Yes. Representative Manjapudi?
Thank you, Madam Chair. I echo my colleagues on the subcommittee, and that was a major conversation in terms of not impeding 162-page amendment that Representative Grota was working on.
Okay. Yeah. All right, anyone else comment? Okay, in that case, the motion is interim study on House Bill 1408, and the clerk can call the roll.
Representative Simon.
Yes.
Representative Lakis.
Yes.
Representative Bailey.
Yes.
Representative Santon-Stasso.
Yes.
Representative Dolan.
Yes.
Representative Gerhard.
Yes.
Clerk votes yes. Representative Boyd.
Yes.
Representative Brown.
Yes.
Representative Grota.
Yes.
Representative Schmidt.
Yes.
Representative Goley.
Yes.
Representative Schuett.
Yes.
Representative, oops, I'm sorry. Sorry, Selig.
Yes.
Representative Davis.
Yes.
Representative Lane.
Yes.
Representative Gould.
Yes.
Representative Smith.
Yes.
Representative Manjapudi.
Yes.
And the chair.
Yes.
20 yea, 0 nay.
Okay. Motion passes 20-0. Any objections to consent? All right, seeing none, we'll go for consent. And the last one, House Bill 1222, Representative Gould.
Yes, Madam Chair. I would like to, okay, I think, do we have an amendment for this one, right?
I believe so.
I'd like to move to pass on the amendment, and let me find it. It's got a number.
0454.
Yep, 054, 4H.
And is there a second? Oh, no, it's, okay. all right. Gould and Lekis. It's by Rochefort and Edwards. It's not by somebody on the committee. Okay. Representative Gould, do you wish to speak to your motion?
Yes, Madam Chair. I think we're going to have a different motion after this than ought to pass as amended. But I think that voting for the amendment to the original bill is still a good move as this continues on in its process.
Okay, Representative Lekis on the amendment.
Thank you. This amendment makes some changes around, there were I guess, requested by the Veterans Administration people around the language of that part of the bill. And I can't remember. And it makes some changes in the first section. It says it takes the language that had said to an appropriate position or other healthcare professional to appropriate member of the healthcare team. Part of the issue is that, you know, the person that would be appropriate to talk with might, or to consult with, might not actually be a physician. You could have ARNPs and others who might be the person running it, so.
Okay. Any other comments, questions, concerns on the amendment? Representative Manjapudi, are you, no?
I'll wait for after the amendment.
Okay.
I do have some
Reverend Gordon,
concerns
please.
about, so if we can vote for the amendment. All right, let's just get the amendment done. That's the best way to do it. I'm
Okay.
sorry.
No other questions on the amendment? All right. In that case, the motion is to adopt Amendment 0454 to House Bill 1222, and the clerk can call the roll.
Representative Simon.
Yes.
Representative Lakis.
Yes.
Representative Bailey.
Yes.
Representative Santo Anastaso.
Yes.
Representative Dolan.
Yes.
Representative Gerhard.
Yes.
Clerk votes yes. Representative Boyd.
Yes.
Representative Brown.
Yes.
Representative Groda.
Yes.
Representative Schmidt.
Yes.
Representative Goley.
Yes.
Representative Schuett.
Yes.
Representative Selig.
Yes.
Representative Davis.
Yes.
Representative Lane.
Yes.
Representative Gould.
Yes.
Representative Smith.
Yes.
Representative Manjapudi.
Yes.
And the chair.
Yes.
20 yeas, 0 nay.
All right. We have adopted the amendment. Representative Gould?
Madam Chair, I'd like to move interim study for House Bill 122 as with amendment.
Is there a second?
Second.
Okay.
Wait a minute. Do we want to do interim study or do we want to recess this until the next hearing? Is there a
We've
difference?
not-
I just need a little bit of technical advice on how an interim study, can we take it back up next week if we?
No.
Okay.
Interim study is final disposition for the bill. It says that we don't want to pass it this year, but we will continue to work on it.
Okay, thank you, Madam Chair. Then I would like to rescind that motion.
All right.
Because as I understand it, what we want to do is work on this for a resolution for next week, a hearing next week. The exact-
Yes. Representative Broder, do you have a comment?
I do. So this, there's
Point
no
of order.
motion.
We
There's-
have not had a motion.
There's no
Somebody-
motion.
Point of order then. If there's no motion, then there's no discussion because there's no motion.
Ah. We have adopted
Correct.
the amendment. Yes.
I'll make an OTPA motion if that would move things along. That's
Okay,
what I'd like to do.
Representative Lekis moves ought to pass with amendment, and Representative
I'll
Simon
second that.
seconds
Yeah,
it.
we did.
And now we can discuss it. All right. Thank you for that point of order.
Okay.
Representative Groda.
Thank you.
We're on the basic bill as amended.
Right. So this bill, I'm sure everyone's not going to be surprised to hear, is not one of my favorite bills. There have been certain things along. This has had a very bumpy road. First of all, there was no collaboration from the PAs with anybody from the Board of Nursing or anyone from the Board of Medicine. And these are people that they're supposed to collaborate with, and there was no discussion with them about this bill. Number one. Number two, there was no discussion about how the scope of practice was going to change, because within the scope of practice, collaboration between the physicians plays a very important part. These individuals are called physician assistants, and there's a reason for that. Number three, we were told that other states have adopted this, and Maine was one of them. And indeed, Maine did adopt a bill, but it is not this bill. It's quite different than this bill. And this morning we heard that the Board of Medicine has indeed agreed with the PAs on a relationship, and they are willing to put an amendment together which I'm willing to look at, but we don't have it. And it is not, this is something that started out as, I was told, and I think that we heard this too, that the bill wasn't going to be submitted. Then it was submitted. Then it was, well, you know, the PAs are talking about it, but nobody else knows about it. This is not the way to decide how legislation is made. You don't do it this way. It's kind of haphazard. This is an important thing. We're talking about people's health care. And it's not something that we can just say, flip a switch and go, okay, let's do it this way. And then decide that that's not the way anybody else is doing it, so let's do it this way. There's just too many moving parts to this. So I understand the need and the recognition that we want to do something, but I would like to take, and I appreciate Representative Gould trying to make an effort to speak to the bill, but I'd like to see what other states are doing, because in many of these, in these bills, for example, the state of Maine has adopted legislation that does not allow newly graduated students for their physician assistants to practice on their own. And they need a certain amount of hours before they can practice on their own. And I'm willing to take a look at that. And I hope that the committee will agree with me that this is something that we should consider. And I've said my piece. Thank you.
All right, that's very interesting. Representative Blackus and then Menjaputi.
Thank you. Yeah, I understand the concerns of the process. I mean, I wasn't involved in all the history. I mean, I would be fine passing this, ought to pass as amended. I mean, I can mention some reasons for that. But if it's, you know, if there's some process for, and also from the, I think Mr. Cuzzy, I don't know if he's here, we spoke with him earlier, and he said the Board of Medicine would be neutral on the bill as it stands, but they would prefer an amendment that required certain things first. And I don't know what the procedure would be to somehow address that, but you know, if that's where the committee wants to
Representative
go.
Blackus, the procedure to address it would be to add language to the bill, make an amendment, or pass it as is and hope it's fixed in the Senate, which
But
I personally do not recommend.
If I can ask, I mean, to add language, what would we do today then?
Get an amendment.
But we don't have an amendment. Oh,
Or no, we just
to recess it?
recess it and come in with another amendment.
I'm coming back next week anyway.
Representative Menjaputi?
Thank you, Madam Chair. I did express this concern, looked at it from the nurse practitioners versus PA. And PA's physician assistants are still under medical board. And physicians are the ones that are setting the scope and supervision, and to get them to expand the medical care care providers, increasing their numbers so that there is quality, safety in our state in terms of providing it. But suddenly now that, you know, it's not a small tether that's still hanging, but to give the PAs that don't have the same, I shouldn't say not have the same, but the education, training, and the scope of services are very well defined under medical board. And suddenly we are not going to be part of that, but we are going to be independent. They don't have an independent board. So we are really putting our Granite Staters' safety, basic medical healthcare at risk by not having that consistency. So, I mean, I couldn't support this. We hashed a lot of details at the subcommittee, and that was, you know, and I spent few days the week of break to figure out what, how is it. So it is still not there. So I couldn't support it to pass.
All right. Thank you, Representative Lekis, and then Gould, and then Brown.
Okay. Yeah, I don't share those concerns on the health stuff, although I understand them. I mean, it looks like there's two options. One is to try and push through in the vote, the motion we have on the floor. The other one would be, I can withdraw the motion and we can consider the amendment. I'm leaning towards the latter. I have a number of concerns with this. One is, we heard testimony that PAs are having, first of all, that they do have, and there's somebody else can probably speak more to it, but while it's a different training path, they have similar amounts of training and clinical as ARNPs, as NPs. The other testimony we heard was that Southern New Hampshire Family Practice ended up getting rid of all their PAs and replacing them with ARNPs. And we actually, my wife and I deal with them, and we wonder why there were no PAs. And that was because they had trouble getting doctors to do collaboration agreements, but since ARNPs didn't need them, they replaced them with those. And that's, I think, a serious problem. So, my preference would be to pass the bill with this amendment that we adopted for a number of reasons. And I know there's a proposal to add some number of hours under a collaboration agreement and have it go away. My concern with that is that's not going to solve that problem if they're having trouble getting a collaboration agreement.
No, we've got other people.
Right. And
People lined up.
I mean, I'll listen some more, but at least I'm thinking about where to go on this.
Okay. Representative Simon?
Thank you, Madam Chair. And I understand some of the frustration on the committee. I just wanted to clarify one thing that I believe I remember correctly from the testimony. Just on behalf of the PAs, they weren't the ones to originally bring the legislation. A couple representatives did. When they found out that the legislation was brought forward, originally they didn't know what to do with it, but then they're like, no, we really do want this. So then they started to support it. I believe they supported it in subcommittee. And then the Medical Association showed up to testify, and I did ask the question. There are 4 states that do this, and I don't believe Maine was one of those states. But I asked if there had been any negative health outcomes from doing that in those other states. We never heard back from them, so I'm assuming that means that there wasn't anything of major concern, because they did show up for the subcommittee meetings, but didn't testify to that. I just feel like as the process has gone on, more and more people have just kind of come on board with it. If the Board of Medicine is neutral on this, they've looked at it, they've considered it, and they're now neutral on it as it stands. They'd be in support of it directly if we brought in this other amendment, but they're neutral on it now, which means to me that they don't see any major concern of actual harm being done if we were to pass it this way. And I just feel like when you look at the requirements between nurse practitioners and physician's assistants, which yes, has the name assistant in it, but that may just have to do with the way that it developed over time more than how the requirements now. I'm sure that the requirements that they had to go through when it first came out aren't the same as they are now. I'm sure we've increased those requirements over time. If nurse practitioners are allowed to practice independently straight out of school, and physician's assistants have to put in more hours than nurse practitioners do before they can get their degree, it just seems to me that we're not treating everybody equally. These people are just as qualified to practice the medicine in their particular realm of practice, and I just don't think it's fair. And since at this point I don't know of anybody in the medical industry that is outright opposed to the bill as it stands with this amendment that we just passed, I don't see any reason why we would keep physician's assistants from being able to practice independently in the state.
Representative Gould.
Thank you, Madam Chair. So I apologize for what appeared to be waffling. We did a great deal of outreach and research, and I think Representative Lekis, who chaired the subcommittee, has represented it well, but I'll just reinforce that it was very clearly laid out to us by the physician's assistants that their training differs slightly from nurse practitioners, but at the end of 7 years of training, they are equivalent positions. My daughter, who's a nurse practitioner and who testifies before Congress and writes whatever, she's way up there. She clearly stated, if you talk to her or other nurse practitioners or the nursing board, you'll probably hear how their training is superior to the physician assistant's training, but at the end of 7 years, they're equivalent. And so bottom line is, of course, each profession feels theirs is the best, but they both agree that at the end of 7 years, they are equivalent. And for the very reasons Representative Simon has spoken, I've felt very strongly that we shouldn't have a schizophrenic scenario in New Hampshire where we're allowing nurse practitioners to do what we don't allow their exact equivalent on the physician's training side, the physician assistants, to do. However, understanding that there was some reluctance, I was willing to listen to or give a week's time to looking at the possibility that we would need an amendment to get more support. But after hearing all this testimony, especially that the physicians board, you know, the concerns regarding the physicians board doesn't already have procedure set up, I did get clarification that, as we've talked about with all these different bills, the changes that were done last year did not affect the medical board in the same way that it affected all the other boards. So they're in a much better position to be able to have the time to write the scope of practice. If they're saying they would support this bill as it's written, I think it's kind of a no-brainer. We should support it. Neutral, but they would not oppose it.
Not opposed.
Thank you.
Is a step. Okay, Representative Schmidt, were you have a comment?
So I'm fundamentally okay with the idea of the physician's assistants losing that tether that is holding them back in some respects with regard to not what they can do, but how they can do it. And it was emphasized, and I sat in on the subcommittee and emphasized that basically both entities are doing medical care effectively and so forth and so on. It's just a physician's assistant have to have somebody they're tethered to that signs off in a way, but the testimony was that they, in many cases, they don't have any contact with that person. They're not being supervised by that person, and so forth. So I'm sympathetic to the PA's, cause here, but it seems like there's a little bit of factual uncertainty about some aspects of this that would benefit, since we have an executive session scheduled for next week, and we can move this over to that point, that we at least consider investigating some of this unclarity so that we are operating all on the same page. That's all.
Representative Goldie.
Thank you, Madam Chair. And in deference to my colleague, I do want to say there are not exactly the same nurse practitioner or physician assistants. They're not equivalent. They're not exactly equivalent. That is a not correct statement. I just want to go on record stating that there are two different practices. A physician assistant and nurse practitioner are not exactly equal. And I will state that I will not support this. Listening to this discussion around the table that this bill could be made better with an amendment, I think we owe that for this committee to, if we can make a bill better, to do that. I think we all take pride in the work we do here. And I would hope going forward we could do that. I mean, we've done it with a previous bill we're working on, 112 pages, that we said we can make better. This is a short piece of work, and if we're going to do it, let's make it better.
Okay,
I-
Representative, continue, Representative.
I was contacted by some individuals up in Littleton who this would affect. And in the email that they sent, it seemed like the intent was so that they could have their private practice without having the tie to a physician. And if that was the reason this bill was put in, and then all of a sudden got the train rolling for everybody else to jump on board, I'm not sure that's the reason we should be doing this. There's a lot of other aspects to this. we need to look at what the surrounding states are. We've heard from Representative Grota about Maine and the testimony that, well, Maine has done it. Well, they haven't. So let's get the facts straight before we pass something. Thank you.
Representative Brown, did you have a comment?
Thank you, Madam Chair. So I'll apologize to my subcommittee members for apparently having changed my mind up front. To Representative Goley's comment, the New Hampshire Society of Physicians Assistants gave us this document that says differences between PAs and NPs. NPs follow a patient-centered model in which they focus on disease prevention and health education, as well as handling assessment, diagnosis, and treatment. PAs follow a disease-centered model, like physicians, in which they focus on the biologic and pathologic components of health, et cetera, et cetera. So they aren't the same. So yes, in their comparison of the training, there is more training for physician's assistant, which makes sense based on what they tell you that their task is. I'm not going to vote for this, and maybe I'm the only person in the room that thought if I had a physician's assistant that there was a doctor in the building for them to talk to. Apparently, I've been wrong about that my entire life. That's a different conversation, but that's, as far as I'm concerned, that's not right. You can't. How do we untether the person from the doctor and then still call them a physician's assistant? Accepting what Representative Simon said about maybe the history of that. So I can't vote for this.
Yes, well, Representative Lane hasn't spoken yet.
I know I'm only a sub, but listening to this, and I did watch the testimony on this bill, not the subcommittee, but the first public hearing. My question in listening to what Representative Simon and Representative Gould have said is, does it give them 7 years? So they have to go that 7 years and then they're free from this supervision or collaboration. And I think, just to give you an outsider's perspective on what I've been listening to, it's not really a question. It's just, I think that should be made perhaps more clear in the bill, because at least the way I read it, that's not clear. So
thank you, Representative Gould.
Thank you, Madam Chair. And thank you for that question. First, I just wanted to address that equivalent and equal are two different statements. So I wanted to be very, very clear. I was not ever insinuating that they were equal. They're equivalent in that it gets detailed, but nurses follow a 4-year training program that has a lot of clinical hours involved and a lot of direct patient work, whereas and then they get their NP work, most of them nowadays online, and it does not have as many of the clinical hours involved. The patient one-to-one. I call it a practicum because I'm a social worker, but I know there's a medical term for it in the medical field. Whereas a PA can have a very different first 4 years of education, but then their elevated degree is where they get the bulk of all their hours of work with the patients. So much like a doctor, where they're doing their rounds and what have you under a doctor's supervision. So that's where the equivalent comes out, and that's the 7 years. It's 7 years of training. So nurses have 7 years of training that's different than a PA. PAs have 7 years of training that are different than a nurse practitioner. At the end of the 7 years of training, they are equivalent in terms of their skills and their ability to go out and work with patients. So I hope that clarifies what the testimony we heard was. Massachusetts also, I would add, has a bill that they're looking to do. And in the talks I had with my daughter and with the PA assistants, and then this morning, what I heard had come from the medical board, and what the PA Professional Association was advocating is that we look at what Massachusetts bill is, and that's a very good model. It will still make our PAs out of not have equal ground with our nurse practitioners. If we follow a different model, we'll still have a schizophrenic system in New Hampshire where we're treating two equivalent positions differently. But if this committee's happier with that, I'd be willing to take the lead on looking at the Massachusetts piece and looking at the possibility of an amendment for next week.
Excellent, because Representative Groda and Representative Lekis have already signed up to look at House Bill 1271 versus House Bill 1095, and I personally wouldn't want them to add any additional work on their effort. Representative Gould, Representative Schmidt, and
I'll help Representative Gould.
you are busy.
I know, but this is near and dear to my heart, as you know. And I'm sure Representative Lekis won't. Although Representative Lekis has been patiently holding his hand up, so I'm sorry I interrupted. I jumped right in. Excuse me.
Well, I haven't been recognized yet, so.
Yes, Representative Lekis, I'm
All right.
trying
Okay.
to clear the chaff.
Thank you. I mean, I understand the concerns. But we heard testimony. There is the problem with collaboration agreements. The other thing we heard is that although the law says that the physician who signs a collaboration agreement has no legal liability, the insurance companies don't believe that. And as part of signing a collaboration agreement, that physicians are requiring the PAs to have their insurance carry them as a rider. Because I guess, I don't know, the issue is they can still be sued regardless of what we say. And
Deeper pockets.
yeah, probably the case. And I don't see requiring a collaboration agreement, even for a limited time, is actually an improvement on this bill. I disagree with that. It's clear that a lot of PAs have been practicing under a collaboration agreement that is really not doing much of anything. And we haven't seen any serious problems with it. And I mean, the reason for including that, I would think a valid reason, is because, you know, it is a threat to public health and safety, and there hasn't been any evidence I've seen or we heard that that's the case. So, I mean, at this point, I'd like to proceed with the OTPA motion.
Okay. Representative Simon and then Manjaputi.
Thank you, Madam Chair. I just wanted to have the opportunity to address Representative Goley's concern out of Littleton because I'm familiar with it. That's a situation where the physician's assistant had been practicing for several decades, and really without any, in reality, supervision. Although the doctor that she was in collaboration with, you know, still had signatory responsibilities. That doctor is retiring, and once again, this physician's assistant has been practicing for like 30 years. And the idea that a nurse practitioner could have been practicing on their own for the last 30 years, and she was going to have to go out and find a new doctor to have a collaboration agreement seemed unreasonable. And I would agree with her, seems very unreasonable. And so I think it was a legitimate reason to bring legislation before the body. I mean, I think that's a discrepancy that's worth our attention at the very least, and our discussion at the very least. And so I think it was reasonable. And my point just being, just because that was its start, the way that it has developed and the way the conversation has developed since that time has led to, once again, the physician's assistant advocates coming out and being in support of the bill, liking the bill, the medical board saying that they're neutral on the bill, the medical association not being able to provide any data that would indicate that either nurse practitioners have caused any real serious harm practicing on their own, or that the states that have are already adopted, and there are some outside of the state of Maine, Utah, I believe, was one of them. I can't remember all of them off the top of my head. Wyoming, they've been practicing for a number of years without any incident. Increased negative outcomes for patients. I just think that when you take all of that stuff into consideration, I don't want to become biased by the fact that historically we have handled this particular profession in a particular way, and that somehow necessitates the idea that, you know, that's necessary or helpful even. I think what's being proven over time as this has gone on and these agreements have become somebody signing something in Pennsylvania for somebody who's practicing in New Hampshire, things of that nature, which we had testimony is a reality, that we have left whatever it was at the beginning, we've left that as the way of practicing medicine. we're really practicing almost independently at this point anyway, without any harm to the public that we know of, that can be measured in any way, that could be testified to in any way. And so I just think that we should be treating them the same as Representative Gould said, as nurse practitioners who have an equivalent degree.
Representative Gerhardt?
Thank you, Madam Chair. I think the bigger issue is how can we lower the cost of healthcare for the most amount of people in the state? And I think having more people practicing at a higher level would be beneficial. With social media the way it is, if you know a doctor is hurting people, you're going to find out about it pretty fast. And buyer beware at a certain point. The second element, which I totally slipped my mind at the time, is I'll end at that. All right.
Thank you.
We didn't get to be mine.
Oh, I actually remember.
Oh, yes, Representative
All right,
Gerhardt.
I remembered. It came to me. New Hampshire, in multiple listings, has been listed as the freest state, economic reasons, social reasons. So I think looking to Massachusetts for any guidance in any regard would be a bad choice. I'm just going to put that out there. Thank you.
Thank you. Representative Mangiapudi.
Thank you, Madam Chair. If I can focus a little bit on number of PAs in New Hampshire versus number of PAs in the U.S., 800 plus, 140,000 plus PAs in the U.S. Percentage of PAs by specialty in New Hampshire is 37% are surgical subspecialty, 15% all other specialties, 15% internal medicine, general pediatrics or general internal medicine is 1.2%, or emergency medicine. If you think about all the emergency medicine, urgent care, family medicine, internal medicine, and all other specialties in surgical, they're practicing together as a team in a healthcare setting. So this collaboration thing is automatic in terms of the organization providing. Percentage of PAs by settings in New Hampshire, 43.9% hospital setting, 42.7% physician's office or clinic, 11% urgent care, 2.4% other settings, private practice. So this is a small amount. If you're going to untether, you're catering to 1.2% in specialty areas and 2.4% that would jeopardize or upset the apple cart in other settings that is working well in terms of urgent care or physician's office or hospital setting that is providing quality care. So the last 34% of PAs are employed by physician groups or solo practices. So they're already working together with physicians. And in New Hampshire, 42.4% of PAs serve in the rural areas. A typical PA completes 56 patient visits per week with the supervision. This is as a team. So this already is working. So if you're not upset the apple cart and say, okay, everybody can go do independent, we are taking that safety net away. So this is just the statistics that I have. I just wanted to share it.
Thank you. Representative Blekis.
Thank you. I would maybe have a different interpretation of that data. I don't see any apple cart will be upturned. I mean, if they're already working with a physician group, which most of them are, or a physician or a hospital, then not requiring a written collaboration agreement is not going to change the conditions, the situation of their employment. I mean, the people that work together, the medical professionals that work together in such a group do consult as needed. That's, that's part of the way it works. The other thing is in the RSA, existing in the RSA that's not affected by this bill or the amendment, it says physicians' assistants may provide any legal medical service for which they have been prepared by their education, training, and experience and are competent to perform medical, and then there's a list of ones that include or but not limited to, which I'm not going to read. So, I mean, they have to have had education, training, and experience to legally be able to do anything. Whether or not they have a collaboration agreement or not If they're working, as I said, if they're working in a doctor's office or hospital, they're going to be under they're working for somebody. They're going to be under their supervision. And apparently there are some number who are working, have been working independently, in effect, with a collaboration agreement with someone that they rarely interact with. So I really do not see anything which is going to change, cause problems for PAs who are currently working, and that's going to cause additional risk to people in New Hampshire. But what I think it will do, if we eliminate that, is that there are apparently places that would like to hire physician's assistants, but don't do that because of the requirement of having a collaboration agreement. And that's, we had testimony on that. And I was actually very surprised when I was looking at the physicians in our area, or the people to have for primary care in our area under Southern New Hampshire Family Practices, there were no PAs, and I didn't understand why. And it appears this is the reason. And, having a situation where they need to have a collaboration agreement for some number of hours, may offhand make sense. But my concern is it's not going to solve that problem if they're not getting hired and not able to be used in at least some areas because they have a problem getting a doctor to sign a collaboration agreement for whatever reason. Then that isn't going to be solved by such an amendment. And that's why I intend to support the OTPA.
Okay. Anyone else? Okay, the motion is ought to pass with amendment on House Bill 1222, and the clerk can call the roll.
Representative Simon.
Yes.
Representative Lakis.
Yes.
Representative Bailey.
Yes.
Representative Santo Sasso.
Yes.
Representative Dolan.
Yes.
Representative Gerhard.
Yes.
Clerk votes yes. Representative Boyd.
Yes.
Representative Brown.
No.
Representative Groda.
No.
Representative Schmidt.
Yes.
Representative Goley.
No.
Representative Schuett.
No.
Representative Selig.
No.
Representative Davis.
No.
Representative Lane.
No.
Representative Gould.
Yes.
Representative Smith.
Yes.
Representative Mangiaputi.
No.
And the chair.
Yes.
We got 12 VA, 8 nay.
All right. I see. I think not. No, we will not put this on consent.
I'm going to write the minority report.
Okay, Representative Groda will write a minority report, and Representative Lekis will write the majority report. And, okay, we are done for the day. Tomorrow, we're in session. Representative Simon is scheduling subcommittees because he has a couple of bills that need it.
Friday.
On Friday. Representative Groda and Lekis are working out next week, yes. So we will meet again as a full committee on Wednesday to exec all of our bills, we hope.
We'll have one session at 2 and another one at 1 in the afternoon. If you can't make it, I get it. I have enough people. So.
Okay. Yeah, just a second. Representative Selig?
Madam Chair, I just wanted to say it was a pleasure to sub for your committee. The difference between here and my criminal justice committee in terms of the level of equanimity was lovely.
Yes, thank you.